as more members join, breathe in. Let's see, the mechanics of conscious breathing, tactical breathing. It's a nice book. I really got it recently. I hope I had gotten it before.
Yeah.
So, but it's all well. I'll share the photo with you guys. But it's a nice book, and it's the book that's currently being used to train prosecutors and attorneys in the US.
Oh, nice.
So, yeah. Okay, the people who are training them. Okay, these guys. The author is Johnson and Hunter. Brian Johnson and Marsha Hunter. So they train prosecutors in the US and the attorneys in the US, lawyers. So they're saying if you are unable to attend those trainings, this book is the next best thing. It has pictures, diagrams of how you should stand in court, how you should plant your feet, how you should, all those things. How to breathe in, how to get rid of anxiety. And it's all about practice. So they say the more you practice, the more you become better at it, and then everything's going to be okay.
Right. Thank you.
You're welcome. You're welcome. Oh, I can see Vince is in, and more members have started joining in. So as they come in, you can say, what's your experience so far? What do you think about the orals so far from your colleagues? What have they told you? Are you anxious? Are you easing into it? Yeah, anyone can just give their, just talk. It's part of orals, actually, practicing to talk in front of people and expressing yourself. Hi, everyone. Can you hear me?
Yes.
I'm audible enough, huh?
Yeah, you're good.
Okay, no problem. Okay, I'll be honest, I didn't prepare much for today because I thought we would resume afterwards. But now, since most of the colleagues said that they needed some more help, maybe revising, so we decided to have this meeting. So we can go on with today's mock-ups, but then maybe it can be more of revision of the previous questions that have been asked. But as I was telling Ikonya before the rest joined, is don't feel that anxious. The questions you're asked in the oral exams don't translate to the marks that you will get in the oral exam results. The thing is, you will find members being asked, or advocate trainees, people, the guy, your colleagues being asked simple questions, and you'll find others being asked hard questions, because it really depends on the panel. But the thing is, it doesn't translate to marks per se, but how you answer and how you respond to those questions will translate to what you get. So you may get hard questions, but then the way you approach them, even if you're not 100% correct, will earn you a lot of marks. Well, at the same time, you may get very easy questions, but the way you answer them will make you earn low marks, because maybe you answered in a very shallow manner. You didn't go, to the nitty-gritties as the lecturer liked, and so forth. So don't feel, or let's say you're out of the room where they're being asked questions, out of the panel room, and then you find your colleagues have been asked. You find that your colleagues were asked very silly questions, such as, what is your name? Did you what do you want me to ask you, and so forth. Well, at the same time, you are hit with questions on mergers, questions on insolvency, questions, very complex questions. That won't mean that you fail, but it all boils down to how you answer the questions, be it easy, be it hard, and so forth. So don't be discouraged. Just keep on doing what you can do. Keep on revising. Cover the areas where you think you cannot, where you think you're not that comfortable with, and so forth. And then don't despise questions on LPM, on legal writing, and so forth. Because you'll find some lecturers asking 1 or 2 questions from those fields. The reason why we didn't go into legal practice management a lot when we were doing the oral mockups, the previous oral mockups, is because it's more theoretical. And to be honest, for instance, I can't even remember what I really did in legal practice management, because it was more of cramming. Yeah, but there's some, civil, conveyancing, commercial, and criminal, and maybe those are the units, probate, such as probate and trial advocacy, and maybe professional ethics. They have some in-depth. They have in-depth material where you can be asked random questions from anywhere. And lecturers have a knack of asking those questions from those particular units. LWD will get, there won't be hard questions. For instance, you'll be asked, what's the difference between selection and recruitment? You can get that answer straight from the book. So that's why we never focused much on LPM, LWD. They were a bit simple compared to, the complexities in units such as mergers, units such as commercial, criminal, and so forth. So I'm seeing we have a good number, so we can proceed. Even if not that many, we can proceed for today. And then I'll try to answer the questions that some of your colleagues were asked, and see how you can better prepare from the experience that you've had for the past week. Now I can see Noah is in and Lavince is in, so maybe they can give the opening remarks, and then now we proceed with today's session.
Hello, greetings everyone. Thank you, Solonka, for your insightful and engaging comments. They are quite vital to the progress, not only for career progression, but also in terms of advocacy. Okay, so I don't know what your colleagues have told you thus far with regard to the feeling before the panel, say for the questions they'll be sending in the group. So it could be relative, but be it as it may be, what matters is you get to master the art of oral examinations. So what I always say is you see, oral exams is 99% faith and 1% chance. Briefly, I'd say, oral exams is like an art, and not everyone is an artist. So for you perhaps to master how, a magnificent painting is supposed to look like. You know, when you splash painting on the canvas, you have to know, you have to perhaps have the image in your mind how this painting exactly will look like. So, you know, it has to take a lot of what we call broken paint brushes. So by this, I mean, there has to be a lot of practice before your mirrors. And I think I've told you this time without number. So you have to practice, you know, before your mirror. You have to perhaps, you know, try to gauge how your audibility feels like. You could just record yourself on phone and then, you know, sort of replay, okay? And just have a feeling. I mean, hear yourself. How do you sound? Are you convincing or are you talking for the sake of talking? You know, some people talk because they have something to communicate, whereas some people talk because they just, you know, have to open their mouth. You see, there's quite a huge discrepancy between those two, okay? So try to perhaps learn all these, you know, arts when it comes to the oral examinations. And like Solonka said, which I think I would echo and agree with, is that, you know, like you could be asked, you know, simple questions, but your presentation skills is zero, okay? On the other hand, someone else could be asked very difficult questions, complex, ambiguous, you know, questions that perhaps need you to first to even consult what lies beneath your subconscious mind. You know, things that may not really look, you know, easy on the face of it, but you have to dig deeper to understand exactly what does the panel need me to respond to, okay? So questions could be simple, but your presentation skills is zero. Your audibility level is pathetic. Your nonverbal communication is quite strange. It's not appealing, okay? So you see, all these things contribute, all these little things. You know, say for your content, you may perhaps have 100% content. You know exactly what's on your mind. But when it comes to the moment that you would like to deliver that specific content, it becomes crooked. You perhaps deviate. You take, you know, a path headed to Tanzania. In between, you want to take a detour to Mozambique. You see, I mean, those are two distinct, different, you know, destinations, which will perhaps take you longer to arrive at, you know, your intended destination. So have an alignment of thoughts. Know exactly what you want to address and focus on that specific, you know, thought on your mind. Don't be, you know, I know sometimes you get carried away, you know, like you are asked a simple question, but you get carried away, okay? Like you want to perhaps school or even lecture the panel. So you wouldn't even know how that's happening, but best believe it's happening. But you don't know on your conscious mind. Whereas in your subconscious mind, it tells you, keep going, okay? Keep going. I mean, keep doing this, you know what I mean? Keep speaking. You know, by the time you do realize that the panel is bored or the panel wants you to stop, your 10 minutes are over, okay? Yeah, so when you asked a simple question, you could smile, you know, deep inside, you know, and say, now this is my moment to perhaps break the ice. Maybe because the previous questions that you were asked were quite, you know, you see, complex, or they threw you off balance. Yeah. So you want to salvage yourself. So be concise and to the point. In other words, I mean, you could address more by speaking less. I don't know if you get that point. You could address more by speaking less. Okay. At the end of the day, you have to know you have a timer that is supposed to run out after 10 minutes. So limit yourself. Yes, like be uh, arrogantly smart. Like, you know, you could lecture the panel if given a chance. But at the same time, you want to tame that a little bit, you know, to like perhaps give give room for yourself to like nail, other things. So you try to limit yourself, but at the same time, you limit your, content, your presentation, your delivery skills, and your audibility in one level, okay? So don't try to perhaps outweigh the other one. Like you have 100% content, and then when it comes to your delivery is 40%. You see, that's when you have sort of outweighed yourself. So yeah, I mean, those are the only thing needed for you to pass orals. At the end of the day, the foundation is you've read, you have the content, that's the foundation. And you know a house wouldn't just exist based on a foundation. It needs pillars to support that foundation as you scale up. Perhaps it could be a 2-story building, depends. So you have pillars. You need to put up, steel. You need to, put cement around it. You need to have, iron sheets and water view. Okay. So build everything, I mean, build your content from that. I mean, build your presentation from that content that you have, okay, as a foundation. So it's easy to pass orals. At the same time, it's also easy to fail orals. And the difference will only come with those two things that don't, have anything to do with content. You have the nonverbal communication, you have the, delivery, presentation skills, those things. Okay, yeah. So that's what I can say. It's doable, 100% doable, and all matters is gather enough courage. I mean, don't panic. When you panic, it erases everything. Things that perhaps you wouldn't even forget come what may. Even if you're walking up, in the wee hours of the night at 3 a.m., you could tell, like, I could answer this question. But when you get to that room, that cold room, I sometimes call it a morgue because it feels out of place. But your presence is needed there. So you just do what you got to do. But it's your confidence that will drive you there. Okay? It's your confidence that will make you show up even before you speak. Okay? So practice. I mean, practice makes perfect. I mean, your oratory skills, your nonverbal, communication, those are things that really, really, and really matter. I saw some, concerns that people, they were told to relax when they got to the, to the oral exams room because the panel saw that they did panic. Well, it happens, and people are built differently. Sometimes anxiety. So Lonka was talking about things to do with, those aspects, that will perhaps make someone not to give their best. The anxiety you have, you got to breathe in and breathe out. Yeah, I mean, sometimes anxiety would actually make all the butterflies in your stomach turn into bees. So they sting you from deep inside, and you really can't contain it. It happens. But I told you the different ways of managing all these kind of, things. Okay, so believe in yourself. But regardless, build everything on the foundation of content. Your flow of thoughts, your oratory skills, your audibility. Sorry, your oratory skills, your presentation skills, your audibility. Those things should be premised on the foundation of the content. Yeah, that's it from me today. I think Noah, you could take up the space, and then we could proceed now with the mock-ups. Thank you.
Thank you very much. Before I give my word of advice, I hope I'm audible. Mr. Solonka, can you confirm?
Yes, no, you're very audible. I can hear you very well.
Okay, there's a fourth panelist who is supposed to join, and Nikama amesahau login zake. So I'll refer her to you, Mr. Solonka, so that you can help her. Now,
okay.
Yes, so my advice to you, just to add on to what my predecessors have said, people tend to take the week one question so lightly. because you might be asked a simple question like, what is jurisdiction? And when the results come, you find that students are bragging, have been asked easier questions. However, when the results come, it's the opposite. And you tend to wonder why. It's because they take these questions, these simple questions, lightly. Now, what you need to add, I don't want to repeat what Pareno and Lavins have had, the issue of your facial expression. When you enter into that room, do not look gloomy or that you are about to die. I know there are circumstances where when your name has been called, when you are leaving your phone and your earphones and you are chewing gum, maybe you are chewing gum outside there, there is always this issue of you tend to leave your brain in that basket also. So you did not worry. It happens. Me personally, it happened to me. I left my brain outside. So it's how you recover, how you enter the room. Because me literally, I just saw my brain just next to my phone when I entered inside there. So it's about how you enter the room. Some people tend to tense. They start shaking in front of the panelists. You go inside there with a happy face. Be confident. Those lecturers won't eat you. Most importantly, when you are asked a question, be polite. Watch out for your non-verbal cues of communication. Otherwise, on our part, I think we are doing our best to help you. And what we can do as for now is pray for you. And I understand, I said it earlier, the issue of Miss Ngania. That lecturer is out of control. When you just appear before her, just start thinking of revising for your bar exams. So if you just hear that name is in your panel, just start looking for past papers. I said it earlier during the first moral mock-ups, and I attested, and there is also a friend of mine who came here and attested it. Ms. Ngania will never give good marks, and I understand. That's something I understand. You have no control. You might be as confident as you think you are. She can demoralize you inside there. So if you just appear before her, I can't say anything. That is out of control. We can also call it force majeure. It's out of control. So we'll just pray for you. We are here if you need anything. You need not worry. People get 7, people get 6, people get 8, and they still pass the bar exams. So don't worry, we are with you. Thank you very much, Nonka.
Thank you very much, Noah. Thank you very much. Thank you very much. So yeah, that's it. In brief, the questions you're asked in the panel room don't reflect the marks you're going to get. You will get a question such as what is jurisdiction, but that question won't mean you're going to get high marks. How you answer that question carries the factor of what you will get. So it's about how you answer the questions, not what the questions are. You may get very hard questions, but you may convince the lecturers and then end up scoring very high marks. This is something that we saw from our year, and it's something that is there. I remember the previous year there was a colleague. Okay, it's my senior right now. He finished a year, 2 years ahead of me. He finished the bar exams 2 years. I think 2 years ago, if I'm not wrong. The thing is, he told me he failed to answer 2 questions. 2 questions were completely out of reach for him, and he still managed to get 18. In our year, there's a friend of mine. She was asked some complex questions on mergers by Samidolo. So, she wasn't asked anything to do with the merger process per se, but she was asked what was the consideration in a merger between company X and something. 2 companies, unheard of, and then you asked what was the consideration in those mergers. She just played around, so she knew, during mergers and acquisitions, considerations are mainly, it can either be they can be cash or assets or cash or maybe shares. Yeah. So she gave those three. If I remember how she was telling me, she said assets, and then, okay, she mentioned cash considerations. She mentioned shares. So the other company will get shares in this other company. And she ended up getting 17 out of 20. And she didn't answer correctly around 2 questions. Yeah. So the thing is, it's about how you answer your questions, how you portray yourself, and so forth. But then there are those circumstances where you get troublesome lecturers, troublesome lecturers. Always know that the problem is not with you, the problem is with them. So it's never you, it's them. So if you find that the oral exam was unpleasant for you, what you can do is just go and better prepare for the written examinations. And I assure you, we will prepare for the written exams because we will do past papers with you as the way we do the mock-ups, and then you will better internalize and better know how to approach the written examinations. So that's it. Don't be demoralized. Don't be anxious. Okay, it's normal to be anxious, but try to see how you can deal with it, and all will be well. So for those who are anxious, before you go into the room, try and breathe in deeply, and then exhale. Do it for a few minutes, and it has a calming effect. And you will do it. Now I can see your hand is up, then you can proceed to answer some of the questions that were asked during the session.
Yes, Sononka, my sister has joined. Maybe she can say something.
Okay, no problem. Feel free. You can
Sheila.
introduce.
Sheila, are you there?
Hey. Hello.
Yes, we can hear you.
I'm just doing right now, so I'm trying to grasp whatever is going on, but I'll chip in when I can.
Okay, Sheila, that's fine. We were just introducing, and then now we're going to answer a few questions. We're just giving the general overview of the oral exams and how they are. And then, okay, we can go on then, and then feel free to chip in to answer any question. So what questions do you have? Because I remember during the week we received so many questions, and you're at work, your boss doesn't want to see you on your phone, and there are chances I missed some of those questions. So kindly repeat any questions you have, and I'll try as much as possible. We'll try as much as possible to answer them and give you satisfactory answers. Now, maybe to start with, there was somebody who asked me, and I never responded to them, the process of conversion of companies. So he just asked how companies convert and the general procedures of the same. So when you ask such a question, remember, in the oral exams, you have only 10 minutes to be asked questions. So you should take at least maybe a minute or two to explain and answer the question satisfactorily. So when you ask, for example, how do companies convert, the lecturer needs to be impressed, yeah? And how will you do this? You don't need to know everything about the conversion process, but you just need to impress the lecturer. So where will you start from? You will start with the Companies Act, yeah? And the whole process of conversion of companies relates to how a company can alter its status, yeah? And the founding or the provision or the law for it is found under the Companies Act. So if you can't remember the specific section, you can just mention the Companies Act, but it will be very good for you to mention what? To mention the specific section. So the specific section is section 69. So I'm giving you the hack on how to approach some of these questions. So you'll be asked, how can you convert, for instance, a private company into a public company? By answering that question, you should start by saying, under section 69 of the Companies Act, a company can convert itself from one type to another. For instance, under section 69, a company can convert itself from a private company into a public company, from a public company into a private company, from a private limited company into an unlimited company, and so forth. You can go check section 69. Now, after you've mentioned section 69, the lecturer, at that point doesn't expect you to proceed by answering the question in such a manner. So you've already impressed the lecturer. Now, in between, you don't necessarily need to know mechanically how the process is from A to Z, but you can play around with words. Yeah? So you can say, for instance, a private company into a public company, the first step will be by doing what? By having a meeting of the members, a meeting of the members of a company. Why? To pass a resolution giving effect to the conversion of that private company into a public company. So what kind of resolution? It's a special resolution. So there you've answered the question. Now the lecturer knows, you know the law and you know how the process begins. So the company needs to first pass a resolution. So the directors front the idea and then the resolution is passed by the members. So this is a special resolution. It checks 75%. So after the special resolution has been passed, what do? The articles of the company need to be altered. Now, when I talk about altering the articles of a company, it relates to the provisions under the Companies Act. You can go check up there, section 910, around that area, how they define a private company and how they define a public company. So you can note, for instance, a private company limits the number of members to 50, but a public company doesn't limit the number of members. A private company restricts the members' rights to transfer shares and so forth. A private company limits or prohibits the invitation to the public to subscribe for shares. So you have to alter, to remove all these restrictions so as to model the articles of association to reflect public companies' constitution, now the MEMAs, the Memorandum and Articles of Association. So after the resolution has been passed, there has to be the alteration of the Articles of Association so as to remove the restrictions on the right to transfer shares, limits the number of members to 50, and the one that prohibits the invitation of the public to subscribe to shares. So after that is done and so forth, you also need to check out. What's this thing. Now, there's another requirement. So I'm showing you how to play about this. I'm not reading from you, I'm just showing you how to play with such a question. So there's another requirement. Public companies need to have company secretaries. Yeah? So what will happen? You have to do what? You have to ensure that a company secretary has been appointed. Yeah? So it's normally called a statement of proposed secretary, or maybe joint secretaries, because that's a requirement for public companies. There has to be a company secretary. So that one has to be complied with. So you mention such instances to the lecturer. And then after you're done with that, you talk about the requirement as to share capital. So you can go check the Companies Act. There is a minimum allotted share capital. There's an authorized minimum, and it shouldn't go less than that. So you need to go check, be specific. I can't point to the specific section, but I'll do so maybe within the course of the meeting. So then the other thing now is, now you've met all the requirements. Now what you need to do is now lodge the documents for registration for conversion of a company. So how do you lodge the document for registration? You have to file an application for registration of conversion of a company into a public company. So after you've lodged it, what do? You need to have all those documentation that we've talked about. So the new name of the company, the proposed secretary that we just talked about, the special resolution that we talked about, the articles that have already been amended that we talked about. What else? What else can you think about? What else? And so forth. So after you've presented all that to the registrar, the company is the company now, the registrar proceeds to register your application, and the company now converts. Now, this is the thing. When you ask such a question, okay, when you go to do your pupilage, you will find that there are specific forms under the business registration services, BRS website. The specific form for conversion of companies is Form CR17. Form CR17 is a specific form for conversion of companies. But the lecturer doesn't want, I presume the lecturer, you haven't done this in class, so the lecturer wouldn't expect you to have to go into such detail. In an oral examination, the lecturer just needs to know, you have an idea. You have an idea, you just don't keep quiet. And I assure you, if you ask such a question and you mention what I have just mentioned, even if it's not sequentially, you will get good marks. So start by saying a company can alter its status, or companies can be converted from one entity to another. Pursuant to Section 69, for instance, you can convert a public company into a private company and so forth. After you're done with that, the next step is say that for a company to first convert, a special resolution has to be made. After the resolution has to be made, the next step is to alter the status and then ensure that other nitty-gritties have been met. For instance, the requirements as to the minimum authorized share capital in public companies. For instance, the issue to do with company secretary, there has to be a company secretary and so forth. And then the issue to do with the change of name. Now, after you've done all that and you've complied with all the statutory requirements under the Companies Act, you lodge an application with the registrar and you attach and annex certain documentation. The new name, the statement of proposed secretary, the share capital, the amended articles of association, the old certificate of incorporation. What else? Yeah, and you're done with that question, the special resolution and so forth. And I assure you, if you do that, you will get good marks. No lecturer is looking for you to go into the nitty-gritties of saying from this. If you know them, very good. But if you leave it at what you've just talked about, you get your full marks. So that's one question that I was asked during the week. I hope the person who asked me is in the room, so that is in the meeting, so that at least I have answered her question satisfactorily. Proceed to ask any question that you feel was a bit heavy, then you can try as much as possible to answer them, if they're answerable. So kindly just proceed.
Hi, Kareno. Hello.
Hi, Nyongesa. Hi, Cynthia. How are you?
Hi, good. There was this question of if you're disgruntled by your pupil master during pupilage, what steps are you supposed to take? Everyone I'm asking seems to be giving inaccurate answers, but what is like the direct, correct step you're supposed to take?
So if, let's say, there's a disagreement between you and your pupil master. Hey, some of those questions. Okay, so this is the thing. I'll give you from my own experience. Not that I have been disgruntled by my pupil masters or so during pupilage, but if you ask such a question is, there is a pupilage book that you will be given after you're done with the exams, and then you have to fill this book daily, and then monthly it has to be signed by your pupil master. So you need to remember that when it comes to pupilage, you can change your pupilage venue at any time you feel like, but it has to be, your book has to be signed. So the thing is, if you're disgruntled by your pupil master, and you see that you cannot, for instance, you cannot tolerate the environment, the proper thing to do is go to report to school and then tell them that out of these 6 months, I have successfully completed 3 months. This is the evidence. And what is the evidence? Every month, your pupil master has to sign your book. So you can go show them that, I've completed 3 months, but due to these and these and these, I wasn't able to stay in that environment, and you explain to it, because you will hear cases of sexual harassment, you will hear cases of being mistreated. You don't take it in, you have to report. Some of those are even criminal in nature, so you can even open up such questions. It's even coming to my mind. If you're sexually harassed during pupilage, it's a criminal case. Go report it. Yeah. If it's just some slight misunderstanding, you can just go report to school, because it has a dispute resolution mechanism, and then submit your evidence, and then we will proceed to address it as well. That's how I would approach it if it happened. Now, maybe since I have Lavensis here and there's Noah here also, and Sheila who are doing the pupilage, I don't know how they will approach it. Just they can give their words on it, because personally, that's how I would have done it. if it's ever been disgruntled and the mistake is criminal in nature, you just go report it to the police and then go report it to school. If it's some misunderstanding and I think that I can't stay in that firm, I just go to school and tell them that, I finished, I did 3 months, 4 months, this should be tabulated. I've found another venue where I can complete my pupilage. So let me complete. You'll have to take practicing certificates for the new advocate you want to go learn under, and then go submit them to school and it will be admitted. So kindly, that's how I would approach it. Lavince and Noah can give their view, maybe share. Noah or Lavince, how will you approach that? Noah, how will you approach such a situation?
I think your procedure is correct. There's one of my firm members who happened to had a disagreement with his pupil master even before 2 weeks lapsed. The reason was not 2 weeks, 2 months. Sorry. The issue of the burden, the associates giving too much work, and then they are harassing you. So she couldn't take it anymore. She was working in this Three for Better's friend, Dunstan O'Malley's farm. The issue was that, and you will find this thing, your people must want to burden you with what? They will be killing you. So it's about how you manage it. So what happened to her is that she couldn't take it anymore. So she went and did the same procedure. You just carry that book with it being signed up to the date, the day you left. Then you tell the school whatever your problem is. If they can solve it using the DR mechanisms, then it's okay. If it's out of their hand, they can change. If you have found a new place, actually she found a new place. So she managed to change the pupilage centers. And I don't know if it is true that, but according to research, she was the one who was telling me, and I didn't buy the idea that actually that firm that she was working in was really paying well. But it was directly proportional to the amount of stress. So she decided to go to a low-paying firm where you have control. So I don't know if that is true, but so long as it's true, that's the legal way of solving the issue of pupilage, unless Sheila or Lavince want to add anything.
Hey, can you hear me?
Yes, we can hear you.
Awesome. I think the content and the procedure you gave is quite satisfactory. So a friend of mine as well, he did his pupilage, I think, for, is it 2 months or something? So there was a day he was sent, I think it was to appear, in the High Court. And remember, this is, a pupil. Pupils out here masquerade as advocates. Just pray you don't get caught sometimes, especially when you appear before, High Court judges. It's crazy. So he didn't know he was supposed to appear for the High Court. It was a matter to do with probate, I think. Yeah. So he got there, and he did realize that there was something, that needed to be done, which actually he didn't have authority, to execute. Remember, this is a matter that is coming up. So you are thrown under the bus by supposedly your pupil master. So you are there, you are caught in a bewilderment. You don't know what to do. You are in a dilemma. You are in a fix because the High Court judge is there. So that same day, he went, to the office and just told him, without, writing any letter, told the, pupil master that, you know what, I'm leaving. And that's how he packed his bags, went over to start afresh. So right now is somewhere at View Park Towers. For those who know View Park Towers, I think you have at least a quarter of Kenya School of Law students, class of 2020, doing their pupillage there. There's a tall building in the CBD. So he's there, right now. So he had to change, the forms because that was quite, I think I would call it gross misconduct. Even if it were up to me, you can throw me under the bus. You can tell me that, hey, you're going to appear before a high court judge. See, like the high court judge, like, Majanja. You know how thorough he is. And you are there. You are holding brief as a pupil. It's crazy. No one would really want to be in such a mess. So when they ask you, okay, counsel, you've come to hold brief, for whom so and so was on record, blah blah blah, and then apparently that judge declines. Perhaps for the file to be set aside or something, and he tells you, you know what, we are proceeding with the hearing. you know, I I I don't know what one will do at that particular moment, but it's one of those moments that you wouldn't want to be, part of. It's crazy. So what you could do is to just resign. Just go away, because I think the Kenya School of Law caps, the period upon which one may change, their law firms or change pupil masters, because not everyone, does their pupillage at law firms. So I think it's 3 months. So beyond 3 months, you can't change, pupil masters. But I think that one, should be subject to amendments, because now what happens if, for dear ladies here in, you are sort of subjected to consistent, sexual harassment. And the 3 period that the Kenya School of Law has given has actually lapsed. And, by default, you can't change, your pupil masters. You see, when it comes to such exceptions, I think Kenya School of Law ought to perhaps, be soft on such regulations, to perhaps allow, such cases, that are quite inevitable sometimes, So it's I think it's one of those areas where KSL should perhaps, amend so that it becomes perhaps, open, so that you could even, change pupil masters even beyond that 3-month period as a cap. Yeah, so the procedure I think that you gave, so that's quite fundamental. So I can't think of any other, procedure that may be ideal. Yeah, so that's it. I can see quite a number of hands here. There's Gikonyo, Wanjiku, there's Mauko Ogwade, there's Waroro Mary, there's Munyoki Pamela. I don't know, who wants to shoot their shot first? Gikonyo, Wanjiku, please do.
Hi, good evening.
Good evening.
So there's one question I have seen. It's what are the considerations? I'm not sure if it's a judge. I think it's a judge. What considerations does the judge make after sentencing?
Right. So Longa, should we perhaps take all, all the questions so that if we were to address them, we could address them collectively?
I'm not sure. What do you guys suggest? Will the questions get lost in between? We address one-on-one. What do you think? How do you prefer we move on?
I think we are progressing on well.
Okay, nothing. So you can take one, and then as we move on, you go to one asked, we answer, and then so that at least we do away with. Okay, one member asks exhaustively all the questions they have, and then we go to another member and so forth.
All right.
Is that fine?
When you was that the only question you had?
Yes.
So in in a nutshell, you're asking what considerations would a judge, put in place after sentencing. Is that it? If I got your question right?
Yes.
Well, you see, sentencing is the last, process in the criminal justice or trial, system. So perhaps the question maybe would have been um, ideal if it were, what happens or what considerations take place after, no, before sentencing, because I don't see any other consideration that maybe taken after sentencing, because perhaps that's when the accused person is even taken to the to prison, depending on what crime they have committed. So yeah, I mean, I think that committal to prison, that's the only thing that happens. I mean, after sentencing. So before, this is quite a common question, by the way. I mean, what's the difference between conviction and sentencing? So you see, actually, it should start. What's the procedure between judgment and sentencing? Okay, so we have a number of procedures or things that take place between judgment and sentencing. And one of those things, like you could be convicted, but you can't be taken to court, at that specific moment, because what happens before one is taken to court is, sentencing. Like you are convicted of the offense. In this, once you are convicted, there is what we call there's a mitigation factor between judgment and sentencing. The things that the judge himself or even the chief or the magistrate need to take into consideration before perhaps giving their sentence. Back when we were doing our judicial attachment, I did my judicial attachment at the Chief Magistrate Court in Eldoret. So it was our work, by the way, to write the judgments. What the resident magistrate will come to do is to, give the sentencing, and yeah, that you see the court orderlies. I mean, those police officers immediately, handcuff this particular accused person, not even an accused person, a convict, basically. Okay, so they handcuff the convict and immediately transfer them to prison, maximum prison, whatever type of prison. Yeah, so all those mitigating factors, it could be perhaps a report from a probation officer. You have just a number of things that the judge should consider before, making the final pronouncement. Yeah, so after the sentencing, that's basically prison. So Solanka, I think you wanted to add something.
Yeah. Actually, you're very right. So the thing is, after the judge gives a sentence, they call that that's what they say. The functus official, yeah, it ceases to act because they've already given a sentence. They've already convicted you and sentenced you. The only recourse you have is appealing. Okay, within 14 days. So the question I think they were asking is, what are the considerations during sentencing that the judge or magistrate takes into account? And when you ask such a question, the thing that should click at the top of your mind is the sentencing policy guidelines. So there is the sentencing policy guidelines, what the courts will look for or will look out for when it comes to sentencing. So you can Google up the sentencing policy guidelines and then read from there. But in a snapshot, what is provided for under the sentencing policy guidelines are, for instance, proportionality. Yeah. So the judge, there are some matters that start at the High Court, but the judge or magistrate will look at various factors. For instance, proportionality. So is it proportionate? The punishment that the judge is giving, is it proportionate to the offense that was committed? Yeah. What else? The court will look at your behavior during the trial. The court also looks at the victim. So these are things that you throw in to show the lecturer that you know. So we talk about the victim. the court has to take consideration of the victim. Yeah. Victim impact statements and so forth, and then you bring in the criminal procedure code inside there. When you're talking about victims, you can talk about from section 329 of the CPC, of the criminal procedure code. Talk about the victim, the considerations of the victim. Yeah? Talk about the prevalence of the offense in society. So you can even bring in examples into such questions. So for instance, you've seen that there are circumstances where, okay, let's say, for example, corruption claims. You will find judges or magistrates tend to give harsher punishments so as to provide a deterrence for such a crime. And then give a practical example. You remember Waluke, the MP, and Wakungu, the mother to the CS, to the former CS who's now an ambassador. They were given a hefty punishments to pay, I think, over 1 billion in fines, failing which they go to prison. So those are some of the things that you will discuss. The starting point will be as Lavins was talking about, the reports from the probation officers and so forth. But the starting point is mentioning the sentencing and policy guidelines that guide the discretion of magistrates when issuing out sentences. Yeah.
Also,
other things. Yeah. Yes, Lavins.
something I needed to add, or perhaps just finish up on that. I'll come after you.
That's fine. I'm actually about to be done. So after you've mentioned the sentencing and policy guidelines, then go into the specifics. It's better if you give examples to show the lecturer that you are abreast with current issues and situations. So talk about the facts that we've talked about. The fact that how was the accused person? Okay, now this person has already been incarcerated, has already been convicted now. So how was he during trial? What effect did the crime have on the victim? Because the court has to take consideration the victim's statement as to the impact of the crime. You also need to look at the issue of deterrence. The courts look at that. Deterrence, what Lavins rightly mentioned, reports by the probation officer, remorse, and so forth. There are so many mitigation factors when it comes into criminal litigation, and that is just one of them. Those are just a few. There's so many things. It's up to the art and craft of the advocate for the accused or the convicted person to try and sway the court as to why the mitigation factors matter. During judicial attachment, I don't know whether you saw those type of crimes whereby somebody was incarcerated or has been convicted because of maybe domestic violence. And then the mitigation is, I am the only man in the house, I am the only one who provides for them, I am the only one who does for it. So that's what you will bring out, that the court looks at mitigation factors. And how are they guided? They are guided by the sentencing policy guidelines. And then now go into the nitty-gritties, give examples, throw in the criminal procedure code, 329 with regards to victim impacts, the criminal procedure code with regards to sentencing, throw in, current affairs situations. There are so many corruption cases. There are rape cases. You've seen rape cases. There are murder cases. You remember the lady from Langata who was given, I don't know if it's life or death, and so forth. That's how you would approach such a question. That means maybe you can add up anything you wanted to add up. And I hope it's satisfactory, Deacon.
All right, thank you. There's also what we call suspended sentencing. Okay, like if a court itself, sort of imposes a sentence of imprisonment for any offense for a term not exceeding 2 years, it can itself, suspend the sentence for a period of time. When you look at section, I think 15, subsection 1, of the CPC, it sort of highlights this. And then if the offender himself, is convicted of any offense, during the specified period, the suspended sentence takes effect, and the sentence for the subsequent offense, would have to run now consecutively to the suspended sentence. So that's in accordance to section 15, subsection 3 of the CPC. Sentencing could take different forms. There's fines. There are also what we call non-custodial sentencing. I don't know if you've ever heard of it, but I think you have. So the primary objective of non-custodial, sentences is rehabilitation of offenders. Okay, so by by serving these, sentences, offenders take responsibility for their actions and at the same time, remain in the community, which provides an environment which is quite conducive to what we call rehabilitation. And you have to know that, some non-custodial sentences such as paying compensation and restitution deliver restorative justice to the specific victims. And then imprisonment also is one of the types of sentencing, and then death sentence as well. There's also quite, what is this? When the sentencing policy guidelines, I think page 3 or something, it says that generally, a maximum sentence should not be imposed on a first offender, unless there are quite a number of aggravating circumstances, okay? And I think there's this case of Charo Gumbao versus Republic. It was in Mombasa. It was referenced in the case of James Njau versus Republic, whereby now the Court of Appeal at Nairobi, I think under paragraph 23 or something, of the sentencing policy guidelines, set out an exhaustive list of aggravating circumstances. So there are those ones that will perhaps, tell the court that, if these meet perhaps the threshold of aggravated circumstances, then this is how we should impose this particular sentencing. But the general rule is that, the sentences, any type of sentence imposed by the court should be geared towards achieving a number of objectives are set out in the sentencing policy guidelines. And these include, but not limited to, you have retribution, you have deterrence, you have rehabilitation, you have what we call restorative justice, you have, incapacitating the offender, and then lastly, you have denouncing the offense itself on behalf of the community. So those objectives will guide any form of sentencing imposed by the court. So I think you are answered. Dikonyo, I hope that helps.
Sorry, yes, that answers the question. I had one more question. Sorry, forgot. There was a question Dr. Omosa asked. How would you advise someone who has been arrested for not wearing a mask?
Solonka, will you take that or Noah?
Well, I remember this was it was a very common question. It was a very common question during our year. Who remembers the answers to? Noah, do you remember the answer to that question? I'm trying to remember. How would you advise? How would you help your? Most of questions. Who has been arrested for not wearing a mask? Okay, if I was asked such a question, how I'll approach it is, this person has already been arrested, he's gone to court. The first step is go to the court, not to court, sorry. He's been arrested and he's at the police station. He has to be available to court within 24 hours. That is right. So you have to throw in article 49 there. Yeah. The next step is to ensure that they frame a charge. So you need to check. He's been charged with X and X offense. Is that offense provided in law? So if it's not provided in law, then it's prima facie, the charge cannot stand and the person has to be released. So you need to be given the charge, the particulars, the charge sheet, I mean, where he has been, the charge sheet for his arrest, the particulars of his arrest, any evidence, witness statements, and so forth. That's how I'll approach it. Because if somebody has been arrested, that's how we will approach it. So he has to be brought to court before within 24 hours, check the charge, his accusations level, the accusations leveled against him. He has a right, he has various rights. He needs to be given all the evidence that is available. And then, yeah, if he was maybe arrested on let's say on a Thursday, the lecturer maybe may be looking for you to talk about these types of bail. There's police bond and so forth. So you go to court, not to court, to the police station, the OCS, let your client be released on police bond. and then he will avail himself in court when he's needed. The other thing is, okay, if it's proceeded to court and everything is in order, pray for bail and so forth. And then if it's like, okay, he didn't have a mask, and I'm not sure, but then I need to go do research on this, wearing a mask and the offense. There was a time where this thing wasn't regulated, it wasn't enacted as a law, and there's this common, there's this Latin maxim, nullum poena sine lege, you cannot be punished, there's no crime without a law. So you have to be, and that's where the charge sheet comes into place. So the charge, if properly drafted, should clearly pinpoint the specific regulation that bars not wearing a mask and so forth. That's how I would approach the question. Noah, maybe you can give your answer. That question was very popular last year. Huh?
Yes, I agree with you, Solonka. And my advice to students is this, and I'll just construe what Dr. Mosa told us. I agree with you, Solonka, by the fact that when you're approached with such a scenario, you run to the rights enshrined in Article 49. Now, when you have been approached with such a scenario, mostly in past papers, you will realize you will be told, advise your client. And what must come out clearly in your answer is the issue of bail, as Mr. Solonka has said. So what I could just advise, when such a scenario comes, you always have to look at the best interest of your client. You don't want your client to sleep inside those cells. So what you must, what must come out clearly in your answer is the issue of bail. And, when it comes to issue of wearing mask, even though nowadays there's no issue of bailable and non-bailable offenses, the issue of mask, when you have been approached with such an offense, basically you cannot be denied bail. So yes, Solonka, you are right. And in an exam when such a scenario comes, please emphasize on the issue of bail. That one you will get a lot of marks.
Yeah, that's it. So actually in our year, the main contention was with the issue of codification of these COVID laws and all. So the issue was, is there a law to that effect? Is there a law to that effect? So Omosa, you've heard about Omosa and his Latin maxim. If you can throw it there, you'll impress him. You'll really impress him. But that's the process. Go to Article 49, talk about all those things. Bail, when he's brought to court, check out the charge sheet. He has his rights as an arrested person, mention them, needs to be availed with all evidence that the prosecution intends to rely on, and so forth. And that's it. And then moving on an extra step, it's true, maybe your client wasn't wearing the mask. So instead of prolonging the trial for no apparent reason, you can just tell him to plead guilty and then now give the mitigation factor. So why didn't he have a mask on at that time? You can say maybe it got torn and he was caught by the police officer when the mask got on at that moment and so forth. Just be creative as much as possible. And then you see when you talk about not prolonging the trial where your client doesn't have a case, you can bring in Article 159 of the Constitution, justice shall not be delayed and so forth. That's how they want you to be. And that's what I was saying. When you enter the room, have an open mind and think. Like when you asked that question, I didn't know the answer per se, but then I sat down for those few seconds and internalized it. So this person has already been arrested. What comes to mind? Article 49. Then as I was speaking, more points were coming to my mind. That's how you should generally approach the whole questions. Is that fine? Yes?
Just to add,
okay.
See, not wearing a mask is a petty offense. Okay, so what I do from my side, if my client is arrested, there are different types of bail. Okay, so there's one at the police station. It's called the police bail. So yeah, I mean, you could pay the bail there while your client is awaiting to be arraigned in court or something. And then, of course, I mean, the only reasonable thing is to fine your client. So you shouldn't, like you said, I mean, you shouldn't prolong such a case because it's a petty offense. And I think most of our prisons and most of our remand centers are full of petty offenders. There was an event we were discussing with the former Attorney General Professor Githu Muigai, why are our jails or remand prisons be full of petty offenders when the court itself, what's leading to a lot of backlog, of cases in the judiciary is because we have a surge in, petty offenders, people who should have just been fined and, let free. Okay. Yeah. So, let your client be fined if at all, he pleads to the charge, and yeah, there's nothing much to it. So, but I would start by paying, the police bail on behalf of my client. So yeah, that one is allowed, and that one is at the police station. Okay, so while he's out here, while the police, puts together the charge sheet and what have you to arraign him in court over some time, yeah. But it's a petty offense. But what, that question should have been specified as a Kenyan. What will you do? Just bribe the police officer and go away, but because you want to sound legally and politically correct, well, choose the legal path. But I know most of you, yeah, most of you will just do away with this. Diplomatically, quote unquote, diplomatically, you know what I mean. So it's to impress the panel, just go through the legal means. But when you're out in practice, the ground, you are vitu ni tofauti. Sasa, yeah, ni hayo tu kwa sasa. So Lonka, back to you.
Thank you. So I hope that's fine, Gikonya. Okay, now the next person can kindly ask the question. I'm seeing Munyoki, then there is Waruru Nyokabi, and then there is Were Immaculate. So Munyoki, you can go on.
Thank you. Mine would just be to ask about cross-examination. I've seen questions on opening statements, closing statements, and I think people have gone through it, and I think most of us know what is expected of us. But when it comes to like cross-examination, for example, there was a question, cross-examine Desmond Peters, for example, or cross-examine Alphonse from, the Faith Mweni case. How do you go about it?
Okay. So when you ask such a question by the lecturers, it all goes back to the Evidence Act. So if you ask cross-examine, you're not supposed to explain or maybe start explaining what cross-examination is and all, but you just move straight to the point. But the hack is in the questions you ask. Yeah. So when you're examining in chief, your questions should always start with, these who, what, where, when, and so forth. Yeah. That's how your questions will normally begin. But if you're told to cross-examine, you have to ask leading questions pursuant to the Evidence Act. You go check it. Can't remember the section very well, but it's there onwards from 150s. I think 149, 150, 151, 152, thereabout. So for instance, let's talk about Desmond Peters' case, cross-examination by the prosecution. Yeah. If you're told to cross-examine Desmond Peters, you can pick the side that you would think you're most comfortable with. If you are the prosecution, you can start by asking the question, isn't it true that you were wearing a blue shirt? That's a leading question. It solicits either an yes or no answer. That's what the lecturer wants you to talk about. But if you start saying, what were you wearing on this day and so forth, you lose marks because there you have not asked a leading question and you are actually examining in chief and you've been told to cross-examine. So if you're told to examine in chief, the question will be, what were you wearing on that day? But if it's a cross-examination question, you will talk about, isn't it true that you are wearing a blue shirt? Yeah? And then you can talk about, there's another question. You can, there was this guy known as Mr. Mohammed. It is a fact, so you can bring this question out. It is a fact that on that day you are caught, Mr. Mohammed, who is properly known to you, identified you. Is it a fact? So then you can finish up by this, isn't it? Isn't it? So the leading question, that's what the lecturers look at. So right now, I can't remember the facts in Desmond Peter's case very well, but I'm just giving you a glimpse. So the lecturers expect, okay, Mr. Monique expects, you've been attending his classes and you've read and reread and reread the Desmond Peter's case. So if he tells you to cross-examine, he wants you to ask leading questions. So you talk about, confirm that on this day in the afternoon, you are along this road near the municipal market. Then the answer that's being solicited from that question is either a yes or no answer, which is a leading question. So I hope you're getting the gist. So that's for Desmond Peters. Now let's go to, for instance, Faith Mweni, cross-examination by Faith Mweni. So you need to understand what's the purpose of cross-examining. You need to impeach the witness, have loopholes in their case. Yeah. So you can talk about confirm to this court that you met Mr. Alphonse 13 years ago. No. Isn't it true that the relationship with Mr. Alphonse was purely sexual as boyfriend and girlfriend? Isn't it true? The answer that you're asking from that witness is either a yes or no answer. Yeah? So why is it? Ask yourself, why have I brought out the aspect of the relationship being sexual alone? Because if I can remember well, the gist of Alphonse's case in the Faith Mweni scenario was that they were not married. Yeah, they were not married. So the issue was a relationship purely sexual. There was no relationship that led to marriage. It was purely a sexual relationship. If you're acting for who? For Alphonse. Yeah. So you can also talk about. There was also the issue of the land. The strongest case with Alphonse is that nowhere in the conveyancing transaction was Faith Mweni present. So bring out that fact. Isn't it a fact that you are not involved in any transaction for the sale of the 13-acre piece of land in Katumani, and so forth? So what the lecturers are looking for, as I sum up, is how you're going to ask your questions. Yeah? There's no specific question they want you to ask. They just want to see how you begin. If you're told to cross-examine and you begin your question by who, what, when, where, you're going to lose marks because those are not the questions you ask during cross-examination. And if, let's say you're told to examine in chief, and then you don't start with the who, what, where question, and you ask a leading question, you automatically lose marks. That's how I would approach it. Is that satisfactory? Does any of my colleagues want to add something to that? Do any of my colleagues want to add anything to that? And to the one who asked the question, did I answer it satisfactorily? Do you want me to clarify a specific area?
Yeah, you answered perfectly. I stand by.
Okay. Who else is there?
Solonga, if I may.
Who?
Samuel Gitao.
Oh, Gitao. Yes.
Colleague. During Mr. Monique's class, especially in cross-examination, he said you should always ask for one fact leading question. That's on cross-examination. And when you're dealing with the examination in chief, ask one fact non-leading question. So
yes.
And that concept, it will be better.
Exactly. So one fact leading question if it's cross-examination. So remember, you ask leading questions during cross-examination. You never ask leading questions during examination in chief. And that's actually one thing he's mentioned, and I really appreciate you mentioning that, the issue of one fact. So the art of cross-examining, the art of examining in chief, it's actually an art. So you should not be asking compounding questions. Sorry if I did ask, but I don't think I asked. But if you ask any compounding questions, it's wrong. Okay, it's not wrong per se, but then you may lose the court and so forth. So one fact, leading question. One fact, non-leading question if it's examination. Thank you so much, Gital. Now we have Waruru Nyokabi. Please go on.
Good evening. Don't know if you can hear me.
Yes, we can.
Oh, okay. So my question is in regards to company law, the issue of derivative. You have been told to, I think, a contrast between derivative action and also the rule in force versus Hobotol. And the other question that I have is, when you've been asked, what steps will you take when you've been expelled by KSL?
Okay, it's good. Lavins, Noah, should I take it and then you contribute? Ama you guys want to try at least take a quick? Any? I begin, then you muongeze, ama how do you want us to go about it?
I can try.
Who's there? Who's that? No.
Gitau, I can try.
Oh, Gitau, okay. Gitau, you're a student, you want to try. Okay, that's fine. You can start with the derivative action and force v habertal, the one that established the rule, and the exception, which is derivative action. And yeah, maybe pinpoint under the Companies Act where it's specifically found. Please go on.
For the act, I'm not that sure, but for the derivative action, this is a principle that enshrines a shareholder to bring a suit in favor of a company where it's a matter that affects the company. But in Force versus Habertal, it was established a good plaintiff principle. So the derivative action acts as an exemption to that case for Force versus Habertal. For the second case, for the second question, in my opinion, because since it's an administrative body, you shall approach the courts by way of a judicial review, which shall assist the student to either reinstate to compel the KSL to do some specific acts. So that's how I'll have answered from my end.
Perfectly well. You've answered it extremely well. That's the answer. So Force versus Habertal, if you can remember Force versus Habertal, the facts were yes.
No.
Yes,
Proceed.
No, it's okay.
No, just go on. I'll come later.
Okay, sawa, no problem. That's fine. So if you remember, okay, just to give you an in-depth and maybe to internalize in case you asked, the facts in Force versus Habertal were that there were some shareholders who instituted a suit on behalf of the company. Now, the court refused and declared it a nullity because they said that the proper party who ought to have sued was who? Was the company itself. So the general rule is that the company should sue for any wrongs against it. That's the general rule. Yeah. So company is the one that ought to sue for anything wrong done against the company. Yeah. The capacity to sue. It all boils down to the capacity to sue. That was the rule in Force versus Habertal. Now the exception emanated from the concept of derivative action, which has been codified under our Companies Act under Section 238 of the Companies Act. So that's the section. So if you've given the small facts, the slight facts under Force v. Habertal, and then you've mentioned Section 238 of the Companies Act, and then you go on and explain what derivative action is. These are proceedings by a member of the company on behalf of who? On behalf of the company. On behalf of the company. Why? Because of, the company itself has not taken up the matter and so forth. So the member has been forced, or so as to protect the company, has been forced to institute a suit on behalf of the company against the persons who have now violated or done anything wrong against the company. And now, when you ask such a question, you should contradistinguish it from the concept of unfair prejudice petition. And this is something most people get it wrong. There is the concept of unfair prejudice petitions. Let me try and remember the section very well. But the difference between unfair prejudice petitions and this other one and derivative action is, for derivative action, you institute a suit on behalf of the company. Yeah, on behalf of the company. So let's say the company's assets have been misappropriated by the directors. The directors have refused to institute a suit against the company. What recourse is there? The recourse there is for you to institute a derivative action under Section 238 of the Companies Act, read together with the various common law principles you can get. However, there's another concept known as unfair prejudice petition that I don't know if anybody has been asked such a question. But the difference between unfair prejudice petitions and derivative action is based on the fact that unfair prejudice petitions is where now the individual member has been wronged. I hope you're getting the distinction between these two. For unfair prejudice petition, the member himself has been wronged. For derivative action, the wrongs are against the company. Yeah, that's the main difference between these two. So for derivative action, you're bringing in a suit. Can you hear me? I'm seeing bad network. Can you hear me?
Yeah.
Oh, sorry. Okay,
Yes.
so for derivative action, it's a suit on behalf of the companies, on behalf of the company. But for derivative action, it's a suit on your behalf. It's your interests have been prejudiced by the company, so you institute a suit. So that's the distinction between the two. So go check section 238 of the Companies Act for derivative action, and then go check section 780 of the Companies Act for unfair prejudice petitions. Now, I would like to invite my colleague Lavins to maybe. He was talking about you want to contribute to something. And then the last question on Kenya School of Law, KSL is an administrative body. If there is any wrong against you by Kenya School of Law, the proper remedy is judicial review, as you had already put. But then you don't end the question at judicial review. You have to impress the lecturer. Yeah? You have to impress. So mention the law. Talk about the Fair Administrative Actions Act. It grants you the right to fair administrative action. Talk about Article 47 of the Constitution. Talk about the Law Reform Act, Section 8 and Section 9. Talk about Order 50.
Solonka, did your call drop? If you're saying,
Hey, did you hear me at all?
no, I think your call dropped or you're muted. One of those.
It was, I think it's network. Where was I?
Fair Administrative Actions Act.
Oh, yeah, I was talking about JR. If you get a question on JR, exhaust everything. Talk about the FAA, Fair Administrative Actions Act. Talk about Article 47. Talk about the Law Reform Act. Talk about everything you can about the issue. I yield the floor to you, Lavins. You had something to contribute. I'm sorry, I had some network issues.
Sorry, Solonka and Lavins, before
Yeah.
you continue, I wanted to interject. I think before getting a judicial review proceeding instituted, maybe first you could approach the Legal Education Appeal Tribunal.
Yes. I wanted to say the same thing. When you look at is it the Legal Education Act or the KSL Act? Yeah, there's a similar question related to that I think somebody asked me when KSL fails to admit you, what recourse do you have? And I think I responded in the group that when KSL fails to admit you based on reasons known to them and not you, you approach the Legal Education Tribunal. While appeal will lie with the High Court. Remember, the High Court has the supervisory jurisdiction over, tribunals, subordinate courts, and what have you. Okay, so the Legal Education Tribunal first is should I call it an indoor mechanism of dispute resolution as established by statute. So once you're done, having perhaps taken your claim before the Legal Education Tribunal, you can move now to the High Court where the appeal would lie from there. Okay, so it's a common question, but I think there are also instances whereby one could easily bypass even the Legal Education Tribunal. Like you want nothing to do with the Legal Education Tribunal. So even the response that Solonka gave, and I think Itau, they will still suffice, because when you perhaps don't want to approach the Legal Education Tribunal and you want to just go directly to the High Court for JR, it's still applicable. Yeah, there are quite a number of court appeal cases I heard of the same. I will share in the group with time. Gikonyo, please remind me. Okay, so it's always a tussle between the two. But yes, you can approach the legal education tribunal as your first, recourse body, or you could even bypass the tribunal itself and go straight to the High Court for JR. So I think those two will suffice. But yeah, so just depending on how weighty your matter is and how urgent you want that matter settled, okay? Yeah, so it's up to you to like decide. But I think the best way just go straight to High Court, because you can never know perhaps what power play takes place, in the legal education tribunal. You never know. Okay, so yeah, that's it. And then now back to the response I wanted to give on force versus habital. I will just summarize in three. There's proper claimant, there's internal management, and then there's irregularity. Those are the three principles under the force versus habital. Okay, so proper claimant is only the company and not the members can commence proceedings for wrong committed against it. Okay, so this principle is itself what we call corollary. Okay, it is corollary of a company's corporate personality. And then the other principle that I talked about is the internal management. So here, where a company is acting now within its powers, so the courts will not interfere in any way on matters of internal management unless the company itself commences proceedings. Okay, so this principle is a corollary of the court's long established reluctance to become involved in any of internal affairs of businesses of that particular company. And then lastly, irregularity. So where some procedural irregularity is sort of committed, an aggrieved member cannot commence proceedings where that specific irregularity is one that can't be ratified by a simple majority of the members. So this principle is again corollary of the principle of what we call majority rule. However, what you have to notice is that the force versus habital case is never absolute. It was not, absolute. Okay, so where with the creation now of the statutory derivative claim, that derivative action was abolished. So, however, there are a number of exceptions that did lie, under the previous common law derivative action, which I think were, yeah, there were four. So the act infringed. You have the act complained of, which was actually illegal, where the act, complained of could only be done or even sanctioned by the passing of a special resolution. And then lastly, where those persons, who controlled the company had committed some sort of fraud on the minority. And then a common question that you could be asked, distinguish between common law derivative action and a statutory derivative action. Okay, what's the status of the two? What's the source of law of the two? What's the grounds for a claim of the two? What are the cover acts or omissions committed by vis-a-vis those two? What is the can claim, what claim can be brought by with those two? Can the claim, what claim can be brought against? There's brought by, and then there's brought against, and then is that claim for negligence for the two? If so, what takes place? So Section 780 for the unfair, prejudicial conduct, 780 of the Companies Act, and then 238, subsection 2 of the statutory the Companies Act, which talks about the scope itself of the statutory derivative claim. So please go through that at your own convenience, because we can't exhaust them within this particular time period. Yeah, so that's my submissions. Back to you, Solonka.
Solonka, can I add something?
Yeah, yes, go on, Ma.
So I agree with Lavin's. When it comes to the force versus sabotage case, basically, may I call it the proper plaintiff rule. So basically, it laid down the majority rule and laid the three principles that Lavins has talked about. One, the company is prima facie the proper plaintiff. Number two, I think the law assumes everything is right with the company. And lastly, there's an irregularity that can't be corrected internally. has to be shown. So the justification behind, I think, that came with this case is that one, it enhances democracy in internal management of a company's affairs. And then number two, the first rule prevents multiplicity of actions. These were some of the reasons as to why it came. Number two, it prevents the multiplicity of actions filed on behalf of a company by other person. And then lastly, basically it uphold the Solomon case that a company is a legal person that can sue and remedy any wrong within the internal affairs. And there's a question that also came with regards to minority right vis-a-vis mergers and acquisitions and takeovers. And I'd like students to know about the two rights that you might be asked that during takeovers or mergers, what are certain rights that are automatic to the minorities? So one, you have to think of the first right is we call it the tag-along rights. The tag-along rights basically, it is the ability to require that in case of a merger or a takeover, one's shares must be acquired at the price that is being offered to the majority. So basically, it's the ability, to require that whenever there is a merger or a takeover in a company, then you being the minority, your shares should be acquired at the price that is being offered to the majority. And the second right that for the minorities is we call the dilution rights. So basically, there must be full transparency in any process in a company whose effect is to change the share capital structure, therefore diluting the shares of a company. For instance, when there is a company restructuring or amalgamation, then there is a requirement that the company ought to publish an information or like a memorandum on the whole process. So that's what I wanted to add.
Thank you so much. No, because that one actually, somebody called me to ask me on the rights of minority shareholders when it comes to mergers and acquisitions. I couldn't actually at the top of my mind think about it, and I did a long time ago, and wasn't taught by Wakimani. So thanks for that. Thanks for that. I hope you've all had those rights that have been mentioned by Noah. Yeah, and then. So I'm seeing Where Immaculate, then Esther. Esther, you can ask a question. Where and then Esther.
Okay. Hi, Fareno. So I have a question about the recent happenings in the Agnes Wanjiru case. So we have an issue relating to extradition that is ongoing right now, where there's a British soldier who allegedly killed a Kenyan woman. Yeah. So then my question will be, if I approach a panel and then they ask me for the process of extradition, so how would you describe that process of extradition, particularly which laws exactly apply? Because I've seen some panelists who are asking if an extradition can happen between countries that don't have an agreement. Like generally, would you be kind to just explain to me the whole concept of extradition, however brief you make it? Because I feel like it's quite a gray area.
That's fine. That's fine. Now, maybe I'll do it in brief. Because okay, extradition is a topic in its own, but let me just do it in brief to explain the concept of extradition. I hope you can hear me well. There's some bit of background noise.
Yes, I can hear you well.
Now, when you talk about extradition, there are so many cases right now. There's the Badambas Kelmo case, Chris Okelmo, that has been rated by the Supreme Court recently. And there is this year, and there is this Agnes Wanjiru case. They all relate to extradition. So let me begin by the Badambas Okelmo. The issue on who has the mandate between the DPP and the AG has now been clarified by the court. In as much as I don't agree with the decision, the court has said that the DPP has the mandate when it comes to extradition. in as much as I don't agree with it, it's binding on us. Yes. Now, away from that, Justice Oko rendered a dissenting opinion, which I agreed with. Away from that, there is this Agnes Wanjiru case also about that Kenyan was murdered by a British citizen. Now, you need to note the differences between those two scenarios. For Agnes Wanjiru, it's Kenya who will be requesting for that person to be extradited. But for the Okemo, I don't know who was requesting for that person to be extradited, but it was a foreign country requesting for those two individuals to be extradited. Okemo. Yeah. So those are two different contexts and two different scenarios. So I'll give you the overview of the extradition process in the Kenyan context. So basically, extradition means to surrender. This is where an alleged criminal is surrendered to another jurisdiction. So this process begins with one major step. There's something known as a note verbal. A note verbal. A note verbal is just a diplomatic note. Now, for instance, let's use the Okemo case. And let's create maybe somebody so that we don't talk out of the abstract. Which country wants these individuals extradited? If somebody has a clue, which country wants these people to be extradited? Okay, let's just say country X. Yeah. So country X, through the Ministry of Foreign Affairs, will send a note verbal to Kenya. A note verbal is a diplomatic note. So what will happen? Once country X sends a note verbal, a diplomatic note, which will basically be stating that this individual X and so, we kindly request that you extradite him because of the following reason: he is guilty of certain crimes and he needs to be tried in So once the note verbal has been received, remember these are some sort of diplomatic communication. So it's from one Ministry of Foreign Affairs to the other Ministry of Foreign Affairs, not to the Kenyan Ministry. Once it's received in the Kenyan Ministry, this thing goes to the Attorney General. This thing goes to the Attorney General of the Republic of Kenya. Yeah. After it goes to the Attorney General, the AG will look at the note verbal and then assess. There are certain things they look at. Now, what are these things they look at? In light of the extradition, these two acts of parliament that govern extraditions in the country. There's the Extradition Contiguous and Foreign Countries Act, and there is Extradition Commonwealth Countries Act. Those are the two acts of parliament. So those are the laws that govern extradition. Extradition Contiguous and Foreign Countries Act and Extradition Commonwealth Countries Act. So what the AG will look at once he receives this note at his desk is whether the offense is extraditable. That's the first thing that he will look at. Is this offense extraditable under law? Yeah. So for an offense to be extraditable, it has to be punishable as an offense in Kenya and in that other country. So you cannot bring a fictitious offense and then you want that person to be extradited, whereas that offense is not punishable under maybe the Kenyan law and maybe the other country that's requesting for this person to be extradited. That's the first thing. And then he will go on ahead and check other things. Yeah. So for instance, if this person will go there and be tortured, the AG will not proceed on with the extradition process or proceedings. Yeah. The other thing is maybe this person is a refugee. The other thing is maybe this person want to get a fair trial. The other thing is maybe this person what else? Political. There's this thing, political detention. So the courts will not the courts. A person will not be extradited if it's for a political offense. So those are some of the nitty-gritty that they look at when they are assessing the office of the AG is assessing the note verbal. So after the AG has checked out all these things, the next step, actually this is actually a step that actually happens before, is you will check whether there's an extradition treaty or an agreement between Kenya and the requesting state. So for Commonwealth Countries Act, it's usually where they've already been designated. It applies to Commonwealth countries. Now for Contiguous and Foreign Countries Act, it applies for this. Okay, contiguous basically means countries that share a common border, and contiguous means sharing a common border. And for Foreign Countries Act, from the wording, it's pretty straightforward. So if you don't fall under the Commonwealth Countries Act, then you could have entered into an extradition agreement with Kenya, and then you will fall under the ambit of the Contiguous and Foreign Countries Act. So the courts will look at that. And then there's also this other thing whereby maybe you haven't entered into an agreement, but for instance, hypothetically, the ICCPR, the International Covenant for Civil and Political Rights, provides that, if this and this happens, it provides for extradition proceedings under the ICCPR. You can resort to the ICCPR or an international covenant, international convention or treaty whereby parties are ratified and they provide for extradition proceedings. So that's it. I'll get back to that in a few. So after the AG has assessed and checked all these things are in order, the next thing he does is he will file an application in court, because remember, the how can I put it? The stamp, the thing that gives the authority to extradite this person is the court. So the AG will file an application in court, and after he files an application in court, proceeds now to lay out the basis. Yeah, that this person, it's a notice of motion application. Take notice, blah blah blah, shall be ordered. For orders, shall take notice that on this day of counsel for the applicant, known as the AG, shall be heard for the following orders. What orders will he be looking for? That this honorable court grants leave for person XX to be extradited, or for leave to be given for this person to be extradited to maybe the US. Yeah? Those are the orders. What are the grounds? The grounds will be that that Kenya has entered, or Kenya is a party to a bilateral agreement with this country, and this country sent a diplomatic note stating that this person is guilty of certain offenses, and then we have assessed there are reasonable grounds, that the offense is extraditable, there's no political offense, and so forth. Those are the grounds you lay out, and then you give out your supporting affidavit to that effect. And then lastly, after you've done all that, this person is brought to court. And then after he's brought to court, warrants of arrest are issued, and then now extradition proceeds with that. Now, note that in light of the Supreme Court decision, they've held that the ODPP is the one that has the mandate of prosecuting. So the DOAG, according to this decision, the full judgment has not yet been released. But from the snapshot that we saw from the Supreme Court, the AG is to only receive the request and then forward it to the ODPP. So the ODPP is the one who is undertaking the mandate of those proceedings, now going to court and instituting the application requesting for extradition. But in brief, that's all to do with extradition. It starts with the first thing, which is a diplomatic note. Remember, and this is why I agreed with Justice Oko. Extradition is not necessarily prosecution or criminal in nature. The extradition is some form of an international legal process. Yeah, so it begins with the note verbal. After the note verbal, the AG assesses it based on those factors that I mentioned. Is this an extraditable offense? Will this guy get a fair trial? Will this guy has rights be violated? For instance, will he be tortured? Is he a political detainee? Is he a refugee? And so forth. After they check that, they now go check the issue to do with the agreements, international treaties and conventions. Is this country that is requesting for extradition, are we a party to an agreement with this person? So they can either fall under the Extradition Commonwealth Countries Act, they can fall under the Extradition Contiguous and Foreign Countries Act, or they can fall under any other treaty that provides for extradition proceedings. Those are the three main areas. And then after they have assessed it, they file an application in court so that the court grants leave for this person to be extradited. You can go check the Criminal Procedure Code, and then you can also check the Judiciary Bench Book, which has the entire process. And you can also check the specific acts, the Contiguous and Foreign Countries Act and the Commonwealth Countries Act. But in a snapshot, that's all to do with extradition. Maybe my colleagues can add if they think that there's something that I've left out. Is that fine?
Yes.
First, I hope you got the gist of it.
Mr. Solonka, if I may.
Yes, please go on.
I just have a small clarification. So after the Supreme Court decision, does that mean that the forwarding of the issue to the ODPP is immediately after, receiving the request, such that the AG will not, have the mandate anymore to determine whether, they
Yes.
should proceed and ask the court?
Yes, according to the Supreme Court right now, the proper mandate is with the ODPP, the Office of the Director of Public Prosecutions, and the AG. So the only thing that the AG does is to receive the request. That's all. That's what the Supreme Court has said. In as much as they disagree with that decision, that's what they've said. But the full judgment is yet to be out, so we are yet to read and analyze their reasoning for that decision.
Yeah,
Thank you.
just to add on that, unless the Supreme Court itself, unless the apex court, walks away from its own decision, because it's the only court that could actually walk away from its own decision, then that's the position at the moment. So receiving lies with the AG, whereas Haji takes the bigger chunk. So yeah, that's the law at the moment. So as we wait for perhaps the entire judgment, we could only perhaps taste what we've been served at the moment. And my interest will be on Justice Oko's dissenting, judgment, because sometimes within most of our laws are founded on majority decisions. But I think I would want, a country that also, premises its own legislations on perhaps the dissenting, judgments rendered by the apex court, for progression of jurisprudence and for enrichment of our own laws. I think dissenting judgments also play a huge and critical role in trying to advance, the rule of law and governance. Yeah, so that's it. Really, I think that's
Solonka, just to add, I've realized nearly half of the panelists are dissenting with the UCO. However much I joined the crew, I do want to echo the sentiments of the concurring judge, Njoki Ndung'u. In the last paragraph, I think she said that the law with regard to extradition is a bit vague. And honestly, it's true. It's very, very vague. There was no clear provision as to who was to prosecute or move the court. And actually, there was a student who called me when I was in the office on the issue, and we debated about it. And I told him, let us wait and see who will move the court. And it's good that Njoki Ndung'u noticed it. There is a disparity in law, and it's very vague. There is no clear provision, even in the Extradition Act or whatever. So I needed to echo that what Njoki Ndung'u said. It's very good when you read through her judgment.
Thank you so much, Noah. Thank you so much, Noah. Well, is that satisfactory? Have you understood now the process of extradition? In summary, in 2 lines: diplomatic note, AG, from AG to DPP assessing all that, filing an application in court gives orders, person extradited. That's the step.
Yes, thank you, Solonka. And if I can just ask one more question in addition to that. There's a question I've seen. You're a judicial officer and an originating summon is presented before you. What do you do next? And my issue with that question is, where is the mischief in that question? Because my answer would be, you just go ahead to determine the contents of that originating summon. So how would you answer that? And is there any mischief, if any, in that question?
To be honest, that's a question. You're a judicial officer and an originating summon that has been presented before you. What do you do? I'll have to think about that, and then maybe.
I didn't hear that question quite clearly. Please, whoever asked it, could you make a recap, please?
Okay, so it's a question that I've seen circulating. You're a judicial officer and originating someone has been brought before you, that is, I presume, by litigant. What do you do next? So I was just wondering, is there mischief in this question? Because for me, I'll just say you determine the content of the originating someone, proceed for hearing and everything. So I was just wondering, is that the answer or is there a catch in that question?
Well, that's a trap. I think the panel member who asked that question was laying a trap. Basically, I mean, how do you perhaps proceed with an OS? I think that's the question they're asking, because honestly, I mean, the question itself lacks spine. Okay, it doesn't have the flesh. It's just bones, and I don't know. It's ambiguous, but you just go through the civil, I mean, procedure way. I mean, the normal way. You ensure that the other party, perhaps has been served with the summons of the same. Yeah, basically, because I don't know how else you could have responded to this question, unless there's something in that question that is missing, that perhaps you haven't included in your.
Excuse me.
Can I answer?
Excuse me, or then
Someone's talking.
could I weigh in on that question?
That's Juma or who?
Yes, my name is Juma Ouko.
Yeah.
Juma Ouko. So maybe you can allow me to weigh in on that question. I think the question is okay.
Okay, proceed, and then I will cap it up.
All right. All right. So I do not know whether that is the position, whatever I want to say. But an originating summons, normally the beginning point of the judge or the presiding officer, you look at it and see whether indeed this is an originating summons. Because remember, it's a shortened version of a plaint. So it is prone to abuse by litigants. So the first meeting, you give directions, you look at it. If it raises any triable issues you get that need evidence to be adduced, remember it's only the originating summons self and the supporting affidavit that is filed. So the first day, the judge gives the directions you look at it. If there are triable issues that need evidence to be called, the originating summons, you give orders that this originating summons now be deemed a proper plaint. It's no longer an originating summons. And then you give the parties, you tell the parties now they should now file their list of documents. They should now comply with the order, the provisions of the 11. And even on that 2, I think rule 3, the list of documents and so on. So it's now you tell them, no, this will not be an originating summons. You turn it into now a plaint. So let it be a proper plaint, and let parties now comply with the provisions or everything that needs to be complied with under order 11. So I think that is what that question wanted.
Well,
thank you. I want to interject.
Just a minute. A minute before you come in. Well, I have no problem with your submissions. When I said perhaps the rules of civil procedure rule has to apply, it was definitely to be assumed. I need not go into the specificity of the of the rules itself. I mean, the triability of that particular suit. Is it properly drafted or everything? Those are things you ought to assume as as an advocate who knows all the loopholes in the civil procedure rules. So perhaps maybe the question would have perhaps placed you at a position to expound more on what exactly constitutes a competent originating summons. I think that's it. Okay. Yeah. So you could proceed. I mean, there was someone who was talking before I did.
So maybe my suggestion is this. You have to look if it's provided under the civil procedure rule or any other statute. Normally, OS is used only where like a civil procedure rule or any other statute has provided for it. So as a judge, you have to look if it's properly provided before you proceed on. So I guess that is my point.
Yeah,
Thank you.
and maybe a rejoinder of that, Dero, just to add. So as I began, as I said, OS are prone to abuse because it's the shortened version of a plaint. So sometimes even advocates, you draft it, you want to go very fast. It is both a summon in there, it's both, a notice of motion, it's everything in a very shortened version. And then together with, you just adduce your evidence of supporting affidavit. So as a judge, normally the procedure is the first day an OS is set down for a mention, you give directions, you look at it. If they have abused, if it is not provided for, that need maybe evidence to be called, if it is something that needs to be proceeded with using a proper plaint, those are the directions you give. And now you say that let this originating summon be deemed a proper plaint. Therefore, parties should now comply with the other provisions of the law, I think, that are required under Order 11. So that is simple. I think that is the catch, and that's what they were trying to ask you. Thank you.
Thank you very much. That was really brilliant. That was really brilliant. Because at first, when I heard that question, I was like, "What as a judge? What do you do?" That's very brilliant. It's great learning. It's great learning. Because yeah, that's a very tough question. I don't know who asked that question. Which lecturer asked that question?
It was just
I'm
by
not sure.
Lisa.
Okay.
So some of these lecturers, okay. The purpose of all maybe to give an right or wrong answer, but maybe to give your own perspective. Juma, you're very right. Lavince, you're very right. Sora, you're also very right. You also talk about the nature of our system. Yeah, we have a very, very adversarial system. So the issue is, do judges really get their hands-on into the case, or is it the duty of the other counsel to look at the application that has been drafted and file an application? But those are some of the questions to be asked later on. As I've said, I'll sit down, think about it before tomorrow evening, get back to you. Solid answers. Thank you for that. Then I'm seeing a hand by Esther Kimani. Esther, please go on.
Hi, I hope you can hear me well.
Yes, you can hear you very well.
Okay, so there was another question that probably we were going through and we had a huge bit of debate agreeing to. The question was, what happens in a situation where there's a sale agreement and the vendor happens to die before the agreement is completed, but the purchaser wants to go ahead with the transaction? What do you do in that situation?
Okay. Yes, Lavins. Okay, you can take that, Lavins.
I think I did respond to this question in the group, didn't I? Or which group did I? Because I did respond to this question. Actually, there are two follow-up questions, I think, which were asked by, is it Mrs. Root or something? I think I did respond to the question. And last, you're not part of our group, or I don't know.
Maybe I can refer. I don't think I saw. Let me just confirm.
But meanwhile, Solonka just proceed.
But it's okay. You can just answer her. Group chats.
Yeah.
Give me a minute. Let me confirm which group I sent it, because I think I responded to that particular question. You have a scenario whereby the vendor has died, and the purchaser wants to complete that particular sale transaction. And I think the purchaser paid some deposit, didn't he?
Yes.
So there is a window in place, right?
Yes.
And that's not the question I'm thinking about. Okay, so with those facts in place, you see, for the the clause, the first, should I call it an introductory clause in a sale sale agreement? But there's that particular paragraph in a sale agreement, that talks about even upon the demise of either party, it will extend either to the assignees or the beneficiaries. I don't know the name of that clause, I've forgotten. So the wife, the widow now at the moment, would apply, first for letters of administration to have that specific land itself, as to be administered now by herself. Okay, if the land itself was owned jointly, that becomes a matrimonial, property. But you can't seek consent from the dead. Okay, so the next step, there is what we call perhaps an addendum. In every sale agreement, I think if you want to make amendments to a sale agreement, there's what we call an addendum, which is basically a rectification. Could be between, perhaps the parties themselves, or just any specific aspect of that sale agreement. So once you have the widow herself, has should I call it the rights to administer that specific land, the transaction could go on. However, the purchaser himself could also become part of the succession cause, simply because when you have a deceased net estate, there is what we call liabilities of the deceased. You see, the deposit was paid by this purchaser. Okay, so it's as if the deceased owed this purchaser, that money. So that's a liability. So the reason why I'm saying the purchaser could become part of the succession cause is because of that specific aspect. So what the purchaser will seek, will be specific performance, from the court to have that sale agreement perhaps enforced. As well, an addendum could include perhaps extension of the completion period upon which the sale agreement would have been completed. Yeah, so I think that's how I would go about the question. So yeah, Solonka, then Juma, then Dido. Yeah.
Okay. Now, okay, that's one way to look at it. Now, this question that you've asked takes two. Yes, you can admit, then you can do it as a discussion. It takes two forms. It takes the succession aspect, and it also takes the conveyancing aspect. Yeah, it's a merger. The succession comes into it, and there's also this thing, what's it called, conveyancing coming into it. So the first step that will happen if the vendor dies and he was already paid is grant of letters need to be taken. So you have to check out this person. Did the person die tested, or did he die intestate? If it was intestate, grant of letters will be taken. If it is tested, grant of letters of administration will be done. Will be taken. So the effect of having the grants taken, the property will devolve into who? The personal representatives of the estate of the deceased. Okay. Once you have the grants, now the area of succession comes to an end, and now comes in the aspect of conveyancing. And I will refer you to legal notice number 278, the land registration general regulations. Yeah, go check regulation number 50, regulation number 50, 55, 55, 56, 57. They've given out the procedure clearly. So what will happen? Under conveyancing, if you check the Land Act, they provide for ways in which title to land passes. There's transfer, there's prescription, there's what else? There's compulsory acquisition, there's transmission. Now, what we're talking about, the whole subject that we're talking about discussing here is under transmission. So what will happen is the personal representative will apply to become for the property to be registered in their name as an administrator. So the property will be transferred to the personal representative. That is Regulation 56. You can check. There's a specific form LRA 39. So once the property has been transferred to a personal representative, go check out Regulation 58. Regulation 58 talks about transfer by a personal representative to a third party. Now, a third party will include the person who had been sold this land initially, the person who had been sold this land before this person died. Yeah. So the process in 5 steps, or let's count them, will be taking out grants of letters of administration. After they've been taken out, you go to the conveyancing aspect. Okay, now I'm not very good in probate. I didn't like the unit, so you have to check out the procedure of taking out the letters of administration or grants of probate and so forth. But after you're done with that, the next step will be to have that property transferred to the name of the personal representative under Regulation 56. Yeah? Under Regulation 56, it provides for transfer to personal representatives. So the personal representative will have that property transferred in their name. When you make that application for the transfer to the personal representative to happen, you will need to support it by the copy of the grant of letters of administration or grant of probate that has been certified by what? That has been certified by the court. Section 56 is self-explanatory. It even provides for the forms. After that is done and the property is in the name of the personal representative, the next step will be to transfer it to the third party, the person who had been sold by the land, by the personal representative. Yeah, that is Regulation 58. So 56 read together with 58. For Regulation 57, it talks about beneficiaries. Yeah. So for instance, that property, he had not sold it, but then he wanted it to transfer to his children. It will be transferred by personal representative to whom? To beneficiaries. But now we're transferring it to somebody who had done, to somebody who was sold this property prior. Are you getting it? Does it make sense, Esther?
Yeah.
Does it make sense? Does the procedure make sense? So that's the whole aspect. So such a question takes the form of succession and it takes the form of what? The form of conveyancing. So under succession, go the due diligence. What's the process of applying or doing the application for grant of letters of administration or grant of letters of probate? Yeah, the specific forms, those P&A 80, P&A 12, P&A, all those forms. And then now after you're done with that, the aspect of ensuring that this land is transferred to the vendor becomes now conveyancing. How does it become conveyancing? You check section Regulation 56. The property after their name. Now let's say you're the personal representative in that transaction. The property goes in your name. After the property goes in your name, that is pursuant to Regulation 556. You go now to Regulation 58, which talks about you transferring that property from your name to who? To this other person. What's it called? The person who had bought the land, the purchaser. And it's actually a commonly tested question, not only in succession, not only in law of succession, but in conveyancing, and you will get it a lot when it comes to the oral exams. I hope let me just project my screen so that I show you guys what I'm talking about. Just have a look at my screen. This here. This is the legal notice I've been talking to you about. This entire legal notice is all, okay, it covers 90% or 80% of what you need to know in conveyancing. This is 56. A personal representative who wishes to be registered as an administrator or executor shall apply to be registered as an administrator under Section 61 under Form LRA 39. So if you have done that, a personal representative who is otherwise not noted on the register, despite having complied, may so forth. So what 56 is talking about is the property being transferred to the name of the personal representative. 57 is transfer by that personal representative. No, it's in the name of the personal representative. It goes to the beneficiary. That is 57. Then after that one, 58 is transfer. Okay, this is different. 57 is different from 58 because 58 is on transfer to a third party, the one that I'm now talking about where you have a purchaser. For beneficiaries, these are the persons who will benefit from the estate to benefit the person. So I hope that one shed some light. Now, I hope that one shed some light.
Yeah, it's well understood. Thank you.
Okay, Juma, your hand is up.
All right, thank you. I think I just wanted to comment on that question, albeit briefly. I associate with whatever you have submitted, but I just want to add or rather comment on the part of probate. Because this question, I think it must have been asked by probate lecturer. So I don't know whether I can comment on the grants.
That's really good. Please go on and comment, because I have actually given you the conveyancing bit, because that's where I told the probate to just provide for the process. Now under the probate, what are the forms you will fill and so forth. But now it comes into the conveyancing bit where the transfer will happen from the purchaser, from the vendor to the purchaser.
Yeah.
Please go on.
Yeah. Yes. So for the conveyancing bit is perfect. So of course, the beneficiaries or even the administrators, for that matter, they can transfer the property to a third party under those sections you've shown. But in this case, you see, on the part of the probate side, whatever the lecturer is testing you is not about the grant of probate or about the letters of administration, because those ones, they take so long for you to get them, around 6 months or even 1 year, the process to the end. And until it is confirmed, and then you get the certificate of, it's called certificate of what? Of grant, and then you lodge it to the registrar for transfer, of course, for registration. So what we are being tested is the issue, there is a grant called special limited grant, because they're saying you are a widow has come to your chambers, the vendor is on her neck. They want the transaction to be completed. So you just move to court, and this thing happens in practice so much in conveyancing. So you move to court and get what's called a special limited grant and a legal notice number 39 of 2002. That grant is very important. It will expedite the process. You just attach the death certificate, and then, of course, you depone an affidavit showing that the urgency of the matter requires that the same should be expedited. So if you get this grant, of course, now the vendor, the purchaser will just pay that money to the estate of that money will just form the remaining balance of the consideration price, will just form part of the estate of the deceased. And then, of course, you go with this limited grant, the special limited grant, legal notice number 39 of 2002. And then you now combine with the conveyancing process you have shown in that legal notice number 278 of 2017. Then the process is done. So that is, I think, Mrs. Ruto, if it is her who asked this question, wanted to know whether you know the types of special limited grants. So that is it, because you cannot start the issue about probate or the issue about letters of administration in intestacy, because the process of just petitioning the court, if it is grant of probate, from 78, that petition together with the supporting affidavit, then it is published, then it is, it takes so long, because the question was asked because of urgency. So if you get time, somebody, you just go to that special limited grant, legal notice number 39 of 2002. It's a very important one. Thank you.
Excellent. Now you merge those. Merge the issues to do with the special limited grants, merge the conveyancing aspect, and this lecturer will be like, this person knows what they're talking about. This person knows what they're talking about. And then when you're merging, remember, if you check, let me just show you to you again. Where is it? I hope you don't mind. These are just papers I'm doing. Just show it to you. Is this thing? Yeah, here it is. So when you check to buttress on that special limited grant and all, you can still post the court using that. And if you check section 50, let me just show you under 15, for instance. They don't not only want, okay, for confirmation. Confirmation happens after 6 months, as Juma rightly pointed out. You can have the certificate of confirmation of grant if you have it, or the grant of probate, or the grant of letters of administration, and so forth. So you match the way he has actually explained it very well, perfectly, more than I could have been explained. Yes, is that fine?
Yes, but I think I saw something contentious and I think it was to regulation 56.
Yes.
Where the personal representative, I think the provision was the personal representative of the estate can make an application to be the administrator.
It's on my screen. You can just point it out.
Yeah. Okay. A personal representative who wishes to be registered as an administrator or executor shall apply to be registered as an administrator under section 61(1) of the Act in the form LRA set out in the 6th schedule. So my question is, if this is the provision, then what is the point of going, or if this is the process, then what is the point of going for grants of letter of administration, yet you can apply to be an executor for the purposes of that transaction specifically?
Yeah, I get your question.
Now, yeah.
Okay, I get it. Now, okay, in as much as don't do what I'm doing right now, never Google statutes. I'm just doing it for purposes of time. The Land Registration Act, I'll open section 61. 61 doesn't talk about executors. You see, if you read section 56, it says a person who wishes to be registered as an administrator or executor shall apply to be registered as an administrator as under section 61. They are not necessarily talking per se as they're not talking about the process of what's it called? Process of applying to be an executor, applying to be an administrator, and forth. No, they're talking about the transmission process. If you check section 61, it's reading, if a sole proprietor or a proprietor in common dies, the proprietor's personal representative shall, on application, using the wording, the personal representative. Now, how do you become a personal representative? What Juma just talked about. You need to have a grant, be it grant of letters of administration, grant of letters of probate, or special limited grants for you to become a personal administrator, personal representative. Yeah. So 61 is talking about if a sole proprietor or proprietor in common dies, the proprietor's personal representative shall, on application to the registrar in the prescribed form and on the production of the registrar of the grant, be entitled to be registered by transmission as proprietor. Are you getting? To be registered by transmission as proprietor. But who can be registered by transmission as proprietor? Only the personal representative. How do you become a personal representative? Through probate. And you see how it's intertwining. Regulation 56 was referring you to 61. Like you're going to be registered pursuant to section 61. 61 is talking about personal representatives being registered as proprietors in place of the deceased. Yeah? Are you getting? So it's not necessarily talking about the succession process. It's only talking about how that personal representative will be registered in place of the deceased person. That is 61. So you still need the succession bit. You need the succession bit because it's not talking about the estate. It's not talking about any other person. It's talking about the personal representatives. Who's a personal representative? A person who holds a grant. You can be an executor or an administrator. Have you gotten the distinction between the two?
Yeah. Like crystal clear.
You've seen, huh?
Yeah.
You've seen it, yeah?
Yeah.
Okay. Now, just since we are here, and that's how you read for conveyancing. Read this.
Hey, could you allow me
come and then come back to
a bit?
Yes.
Allow me come in a bit on that issue.
Okay, please go on.
Yeah, it's Mwendwa. Maybe if you could just shed some light on that issue of transfer to personal reps on the forms. That 39 in practice usually goes with form 42.
Let me open it.
Yeah.
This is form 39.
Yeah.
Just open it. Where is it? But to be honest, if you show the lecturer, if you produce and give the lecturer this entire narration, you're walking out of that room with 19. You show that you understand how these legal systems or these legal units, they merge. There, that's it. This is Form 39, Madu.
Yeah. So Form 39 usually is the one, the disease transfers that property to the personal representative who was named in the confirmed grant. Once you lodge Form 39,
the deceased has already died, so he cannot transfer. But yeah, that's a concept.
It's the personal rep who is transferring to himself.
Yes, yes.
After it's transferred to himself, now that title, again he does Form 42, aingie kwa nini, kwa land.
Yes.
Yeah. So 39 goes with 32. You lodge them together.
Yes.
Yeah, that is the only thing I wanted to add. Then you usually attach the certified copies of the confirmed grant and the certified copy of the confirmation of the grant, which are usually certified by court.
Exactly. I don't know if we should have even checked this, the forms. Can you see? Transfer by personal representatives to who? Yes, can you see it now?
I can see them. Yes.
You can see it, yeah?
Yeah.
So you've now understood that process and how you will approach it. Now, where do you get that LRA 43? LRA 43 is under Regulation 58. Remember the one I was telling you to read, 56 and 58? Let me just open 58 so that you see it. Let me just open 58. So you see, I told you to read 58 to a third party, yes? You remember? So what form do they provide for? Form LRA 40?
LRA 43.
Now when you go to LRA 43, what does it provide for? Transfer by who? Transfer by personal
representative to the purchaser.
That is 60. Okay, let me just LRA 43. Transfer by personal representatives to who? To a purchaser.
Okay, so just to reiterate and just to confirm that I have gotten the process. The first thing to do is apply for the special limited grants, the way Juma has said, because it's a matter of urgency. And then after you have applied for the,
yes, go on. After you have applied and you have received them,
now you go ahead and because you're the person, you have to now apply for being the proprietor of the estate, like the executor of the estate, as under 56 of the.
Yeah, you're actually right. Okay, so so you have the special limited grants, yes? You are a personal representative. Up to their succession you may share. You are a personal representative, yes?
Yes.
Now, in this transaction, you say there was a vendor and there was a purchaser. Yeah.
Purchaser. Yes.
The vendor died. Yes. The vendor, his estate, person X, let's say it was the vendor's wife. So the vendor's wife applied for that special limited grant, as you rightly put out, and they've been given a special limited grant. What will the vendor do? The vendor will go under Regulation 56, under Form LRA 39, will have the property removed from the name of who? The vendor, that personal representative X, the wife, from the vendor to whose name? To her name. Yeah. After that has happened, they now go to LRA 43. Now LRA 43 is this one. That personal representative will transfer that property from her to who? To the purchaser.
Okay. Yeah.
Have you written it down?
Yes.
So what are the legal provisions? 56 and 58.
56, 58.
Yes. If the property was going to the beneficiaries, not to a purchaser, then it would have been 56, 57.
57.
Exactly. And the form is Form LRA 42 and Form LRA 39.
Okay. I've understood now. Thank you.
Thanks. Okay. Thanks a lot, Mendo, for that. It's actually because of you we went to the specific forms now to see them. Okay, now, I don't know.
Hello.
Who was?
Oh,
hi, hi, Claire. Yes.
Sorry, I've been raising my hand. It appears you hadn't seen it.
Please go
so
on.
I hate to take us back a little, but I don't know if it's Noah who said earlier that you apply for limited grant. But my question is under the Law of Succession Act, and I don't exactly remember the particular section as it's now, but it says that you cannot sell or do transfer land before the grant of representation has been confirmed. So what happens when you're applying for a grant at or rather, a limit, special limited grant? That is just a limited grant. It's not going to, does it still give you power to actually transfer to the third party?
Now, okay, because thank you so much for that question. I interested, how can I say it? Probate for me, I will actually let Vince and Noah handle it. But just to answer that specific question on confirmation and all, I'll show you one specific section here. Yeah. Let's go to Regulation 56, and then now I let Kinalavin's Noah, whoever wants to contribute to it. If we check, what's it called? Let me just open it. Regulation. Regulation where okay, for the aspect of this thing, what's it called? For the aspect of transferring to the personal representative, at that point, all you need is this shall be supported by an application under paragraph 1 here shall be supported by a copy of the letters of administration and the grant of probate duly certified by the court. That's all you need when it comes for the first transfer that we're talking about from the name of the deceased to the name of a personal representative. That's 56. Then after we go there, we can go to 58. 58 talks about this. Transfer by a personal representative to a purchaser or other third party under section 61(2), specifically under the LRA, and these are the documents that need to support that application. So you've made that application for the property to be transferred from the personal representative now to who? To the third party. What do you need? You need the copy of the letters of administration or the grant of probate. That's one. You also need the copy of the certificate of confirmation of the grant of letters of administration or the grant of probate duly certified by the court, which is rightly put, as you've said, needs to be confirmed. You also need the certificate of title and the certificate of lease. You also need the land clearance, so forth and so forth. Those are the documentation that you need. You need the grant of letters of administration and you need the certificate of confirmation of the grant of letters of administration under the conveyancing side for you to have the property registered in your name. Now, on the matters of succession and the matters of probate, kindly, I need assistance from my colleagues, Vince and all, because as I repeat, I disqualified myself with regards to succession. It's not a unit that I really enjoyed. It's not a unit that I don't even know how I ended up passing the unit. I had 83, but yeah, it could happen. I'm not an authority when it comes to that. So kindly, anyone, please contribute and assist.
Perhaps you can allow me comment on grants.
It is gone.
Very briefly. So, the question that has been asked is very, very valid. It is true that you're not allowed to deal with estate, especially the issues about real estate. That is land or real estate for that matter. Without, you cannot transfer it without having the certificate, which means the grant must have been confirmed. That is it. So the beginning point is, it is good to know that there's like 3 classes of grants. That the proper grants for the sake of the discussion, let's say the proper grants. That is grant of probate if there was a will that I was appointing an executor, or grant of letters of administration with the written will annexed, where there was a will, but unfortunately the executor was not appointed or the executor died. And also the third one is the grants of a simple administration, also called maybe grants of letters of administration is intestate. So those three on one side. Then the second class, we talk about limited grants. So these limited grants are equally very important. Of course, the law recognizes that you need to have the first one, the real grants, for you to deal with the estate. But there are some situations where, you know, the law knows that there are some situations where you need to deal with the estate of the deceased maybe urgently. Look, where the estate is of a perishable nature, you need to take a limited grant for that matter. You have to conserve the estate. For example, there are adicoligenda bona, where, for example, here you see, or even where there is a kid and you need to get the fees, you cannot follow the first procedure because that procedure is so long. You will take a limited grant. Where the estate is being sued, you will take grant at the later, and so forth and so on. So from there, you see now that, and then there is the foreign grants, which is the third limb. So the three limbs, the main ones, and then the special ones, which can be special limited for purpose, limited as to time, and limited as to property, and so on. And then, of course, the foreign ones. So like in this case, like the scenario that the lecturer asked, you know, she said there's a transaction already that is continuing, but before completion, the vendor passes or dies, and you are the spouse. Okay, the spouse of the vendor has come to your office telling you that the purchaser is on her neck to complete. So because of the urgency of that matter, you will not go for the grant of administration. What do? You will go for the special grant under the legal notice number 39 of 2002. It's a very important grant in such situations. So that after you have, you know, after you just lodge an application for that grant, you become a personal representative. Those documents, the letters of administration that will be given for that purpose. The purpose will be, you know, it's special for the purpose of just completing that transaction. And then the assets or even the purchase price that was remaining there will go to the assets of the estate of the deceased. So you just lodge them to the land registry, and you can get powers to be able to transfer the property and complete the transaction to a third party, because that's allowed under that legal notice number 217 of 278 of 2017. So it is true, but you look at the situation that you are confronted with.
Thank you very much.
Yes, no, go on.
Hey, Juma is speaking knowledge. So yes, I agree with the personally. Before I make my comment, I'm with you so long, and you can bear me witness that during our year, Ms. Ruto used to complain, guys never used to contribute in probate. So I don't know whether in our year this unit was not a guys unit. Yeah, actually there was no male who was contributing. So I share the sentiments. Me personally, I never enjoyed this unit at all. But as a matter of procedure, how I understand is that I agree with Juma. When it comes to such a scenario, you go for the special limited grant, be the legal notice 39 of 202, where you are in a circumstance where the urgency of the matter is so great that it will not be possible for the court to make a full grant in sufficient time. So you realize this guy is on your neck. He wants the transfer to be done. So what you do, you go for the grant. So once the grant is issued, then you do the transfer. So you first, because if failure to do that, and I think none of you have mentioned this, failure to obtain authority to transfer or complete the sale of that property will amount to intermeddling, because you have no authority. Why are you transferring the land without, the grant? So you have to obtain so that you avoid the issue of intermeddling of the deceased property. So once you obtain that, you transfer, you being the administrator, so you will be the transferor. So you'll transfer to yourself. And then once that is done, then you transfer to the purchaser. So that's basically what happens. However, honestly, P&A, that unit I used to just attend it for purposes of attendance.
But perhaps to add, perhaps I rejoined Mr. Noah. I think you just transfer directly to the third party. You do not need to transfer to you. You just transfer as a personal representative directly to a third party. And then I think it is also very important for us to look at this question if it is twisted again and now converted and said, and ask like, what will happen if it is the vendor who has come to your office, the personal representative or the widow is refusing to take out letters of administration? You know, what will they do? So I think it can also be twisted like that. So in that case, you should be well versed with the civil procedure rules, I think, order 37. As the vendor, they can decide, of course, with succession rules also. They have a variety of options. One, they can decide to originate a claim, you know, against the estate of the deceased. Or two, they can decide to cite the beneficiary, you know, file a citation so that they can come and take out letters of administration or show cause why they should not take out letters of administration. Or three, they can file a caveat so that they lay a claim and wait when the beneficiaries or the widows go and take out the letters of administration. They are notified, hey, come, they have come, they are applying for the letters of administration, so you can lay your claim. So it can also be twisted. I think it can also be asked, but on the other side, what about if it's the vendor who comes to your office? So I think that is, maybe it's also good for us to view it in a 3D dimension. Thank you.
Okay, yeah, I was actually coming to mention citation. That's very, very good. You have to make citation. If these persons refuse to take out grants, you have recourse. You can file for citations to cite them to take out grant. That's a very good observation. So yeah, that's how you merge that thing. And you see, it doesn't even matter whether you get the issue on grants spot on. It doesn't matter whether you get the issue on transferring that piece of property spot on, but if you tell the lecturer and explain to the lecturer the concepts under the conveyancing and approve it, you know, you are going to score high marks, extremely high marks. I guess that's satisfactory, yeah?
Yes, thank you.
Okay. Claire, is that fine? And then we go to Dido. Seeing Dido had his hand up for a bit.
Yeah,
Okay.
that's very well explained. Thank you.
Okay. Okay. Thank you. Dido, Abdullahi.
Thank you so much.
Yes.
Been very patient waiting. So, my first issue is, if you allow me to go back on the issue of originating summons, maybe I say something little before I go to my question.
Please go on. Go on.
Okay. On the issue of when you're a judicial officer and before you is an originating summon, in my view, was that it shall be on the questions of jurisdiction. And as you can see, it just states a judicial office. It doesn't really specify whether it's a magistrate or a judge or an adjudicator, for that matter, of small claims court. And an originating summon is brought before your table. So according to Order 37 of the Civil Procedure Rules, we can see that there are several places there where it is specified we can use originating summons. And most of them, I'm not sure if the list is exhaustive, but most of them you will realize is the High Court. For instance, in cases of adverse possession, it is originating summons. The jurisdiction is High Court. You'll also realize it is originating summons is also applied in application for grants, which is done through the High Court. You'll also realize originating summons is also done during an enforcement of a PU, which is done according to Ahmed Muigai advocate's case through the High Court too. So I think when originating someone as a judicial officer, I mean, appears before you, one thing you ask yourself is, do you have the jurisdiction to deal with it? Once you realize you lack, I think the locus case of S. Lilly and Caltech's case kicks in, that when you lack the jurisdiction and the jurisdiction is everything, you down your tools. I think that's basically my view, because when it comes to matters of procedures such as it was not filed well, it was misused, and that maybe it looks like a plaint or something, there are so many cases that state, even Article 199 state that police courts and tribunals cannot put so much regard to procedural technicalities. So those ones can be rectified through many other means. Secondly, just to give also my peace of mind on these issues of grants, the part that I see you have explained in a very good way, and we have understood. And in addition to that, also, after citation, once you realize that the parties are still they're still not going to get those grants, and the matter is as urgent as we have seen, one can also be allowed, pursuant to Section 66 of the Law of Succession Act, is to become an executor or administrator. One can apply, and one of the parties who can apply is creditors. So in such a circumstance where there is a creditor or there's another party who owes you something, because they have that interest in that property, and the parties and the beneficiaries or the parties who are supposed to acquire the grants are becoming difficult, one can also apply after trying the citation process. I mean, after trying the citation process, and of course reporting to the registrar, one can apply to be an administrator. So to my question is, in what circumstances do we not need, or does demand letter not issued? And then secondly, that's the first question. In what circumstances demand letters are not issued? And then secondly, we have when you have a search warrant on a Sunday morning where people are in the church, your client has called you and maybe they are in the church and someone is at the door with a search warrant. How do you go about it? Thank you.
Thank you for that, Dido. Thank you for that. Now, okay, let's begin with. Thank you. That's a very good observation on the issue of OS. Very good observation. That shows how that question can be tackled from different angles and actually make sense. That's the beauty of the law. On the issue of citation and creditors applying, the issue of citation and creditors applying, you need to check. If we check Section 66, there's an order of preference. Yeah. In as much as probate sequence, there's an order of preference. So the creditor cannot just go and apply for the letters of administration before the other previous people who, for example, the spouses and other beneficiaries who have priority haven't applied. And that's where citation comes into play. So if they refuse, you cite them. And if they don't, then now we go ahead and apply.
Excuse me, sir.
Yes.
Just allow me to just comment on one thing, the issue of jurisdiction vis-a-vis originating summons. Because if I don't comment and somebody is asked and they perish, I will not feel good.
Okay, go on.
Yeah, so number one, Mr. Dido. Sorry for
yes,
that.
Please.
So
yes, please.
The issue of jurisdiction on matters of succession is no longer a reserve of the High Court. Sorry. So the issue even of adverse possession is no longer a reserve of the High Court. So you look at Section 9 of the Magistrate Act, it tells you that even the matters to do with land issues and title to land, adverse possession, and so on, even employment and labor relation issues, and even section, on those two courts, the Section 9 of the Magistrate Act tells you approach the court based on Section 7 of the Magistrate Act on issues to do with the pecuniary value. Then if you look at, I think, Section 48 of the Law of Succession Act, it tells you how the jurisdiction on matters of succession should be. It should be in respect to Section 7 on pecuniary jurisdiction of the Magistrate Act, the value of the estate. So it is no longer the High Court. It is not a reserve of the High Court. And that is a very novel thing that was introduced in, section, I think, Section 28 or 23. Look at those two sections, Section 23 or 28 of the Magistrate Act, amended the Section 48 of the Law of Succession Act, which provided that it's the High Court which has jurisdiction and a few magistrate courts that the Chief Justice will elect to deal with succession matters. But today, it is simple. The issue of jurisdiction is based on the pecuniary value that is in the magistrate court, Section 7 of the Magistrate Act. So you cannot say issues that are provided about originating summons only fall squarely at the High Court. No, it is not the case. Thank you. So that's what I wanted to point out.
Thank you. Now, on the issue of Section 9, pecuniary jurisdiction, and also the case law which brought about Section 9, the LSK, Nairobi Branch versus Malindi Law Society, the issue on the jurisdiction of ELC and ELC judges, ELRC judges, and if magistrates courts can hear and determine those matters. So, that's also another point to also look at also. Yeah. And then now to Dido's question on the issue of when do you not use demand letters? And the example that comes to mind are where you want to approach the court and you need to have the element of surprise with you. And what rings to bell if you think about it that way are those two orders. If you're going, for example, to seek for Anton Pillar orders and for Mareva injunction orders. Yeah. So the key things with these two are that you need the element of surprise. If you send a demand letter and a demand letter down there gives 14 days or maybe 7 days or 10 days, dependent on, there's that LSK digest, depending on where this person lives. For instance, you're looking for freezing orders. Yeah. Mareva injunctions. Yeah? You're looking for Mareva injunction. And then you give this person a demand letter. Obviously, that person will go on ahead and do what? And hide just do away with those properties and so forth. Yeah. Same applies to Anton Pillar. So this person you want to search and seize some materials belonging to somebody's house. And then you give this person a demand letter and tell him you have 7 days to, this person will just take those things and go hide them somewhere else. Yeah. So those are the two instances where it's not necessary for you to use a demand letter. Anton Pillar orders, when you're looking for Anton Pillar orders, and also for Mareva, making an application for Mareva injunctions. It's not necessary for you to use that thing, for you to have a demand letter. Noah, gone.
Yes, just to add on what I wanted to twist Mr. Dido's question a little. You might be asked that whenever, sometimes you might be asked that there are certain pleadings or applications that you might not be required, apart from the normal CUs, you might not be required to serve the other party. So basically, the issue of surprising, the element of surprising the opponent. So another thing that might come to my mind is the issue of when you are doing the application for attachment of debts, you ought not to serve the other party. You know, what happens in guarantee proceedings is that what you ought to prove is that the other party, to support a garnishee proceeding, basically there must be a debt due or accruing due. So you have to show that the other party has an account with a certain bank. For instance, if the judgment debtor owes certain amount has a certain amount in excess. For instance, if the money that the decretal sum is 1 million, you ought to prove that he has an amount of 1 million in maybe KCB Bank. So you are not supposed, when you are making that application, there's a requirement that you ought not to serve the other party, which if you serve him or her, unajua he might withdraw that money. So another thing, just to twist Mr. Dido's question, if you are asked if there is any other pleading that you think that you might not need to serve the other party, think of the application for attachment of debt. Salonka, back to you. Your mic is muted.
Oh, sorry. I thought you were talking about. Oh, sorry. That's fine. Yeah, that's it. Okay, thank you. Now the other question on search warrants, I need to think about that.
Maybe, excuse me. Maybe before we depart on that issue of demand letters, there's also one or two very crucial circumstances when a demand letter is not applicable. Apart from Anthony Pilla and Mareva injunctions, also divorce petitions. You don't want to give your wife a demand letter that I'm going to divorce you, and the vice versa is also true. So divorce petitions is also one of them. And I think also proceedings against the government, you don't issue a demand letter, you issue a notice of intention to sue. So I think those are some of the situations also.
Yeah, exactly. That's very true. Yeah, for government to issue a issue a notice of intention to sue. I know that part a bit. That part where you don't give your wife a demand letter. So it's a funny one. Yeah, that's very good. Yeah, and then also you can also note that the issue to do with the notice of intention to sue, it was actually declared unconstitutional by which judge was that? There was a risk, actually it was an old case, 2013 case. The issue of giving a notice of intention to sue was declared unconstitutional. So normally, under the Government Proceedings Act, if you don't give the government a 30 days institution notice of intention to institute a suit, your suit will be defective. Yeah. But after that decision, the court say that you can proceed and do that. So normally nowadays it's not that uptight. You can still sue the government without giving that notice, and the courts will still listen to you. That specific bill was declared unconstitutional by an old case. I'll get the citation and then get back to you. Thanks so much, Juma, for that. And then what else? There is the issue of search warrant. I'm still trying to think about it. Yeah.
Maybe if I can attempt that one.
Please go on. You were learning. Yes. Go on.
For search warrants, we go as per, if I'm not wrong, section 118 to 119 of the CPC, the Criminal Procedure Code. And section 119 is the one that says that or discusses the execution of such warrants, and it explains that such warrants can be executed in any day, including a Sunday, and it can be issued and executed on any day, including a Sunday. So if your client calls you on Sunday and they say that there are police officers who want to search his premises, as an advocate, you're supposed to, or the safest thing to do is recommend to them that they comply with and cooperate with the police officers until the search is done, and then go to court if there's anything illegal that they have done. Yeah.
Thank you so much for that. Yeah, it's a good thing actually. And then article, what's the article of the Constitution on the issue of illegally obtained evidence, and also if there was some illegality, if there were constitutional rights that were violated, still have recourse. You can file a petition in court and then later on and then claim for violation of your rights. Thank you so much for that.
Oh, I forgot about the timings.
The act says that it's any time between sunrise and sunset. I don't know
Okay,
what
yeah.
that means, but yes.
Sunrise, yeah. Thanks so much for that. Now, there's somebody who texted me. Yes, go on. Who's talking? No, go on.
On the petition you're seeking, it's called petition number 15 of 2017. It's the one that rendered the notice of intention to sue being unconstitutional. Because in that case, they were the AG was trying to dismiss the suit under technicalities. So the court found that it is unconstitutional and it's optional. A case can proceed without the notice of intention to sue. A case against the government.
Yeah. I think that's. Thank you so much, Gitao. Thank you so much, Gitao. Now, there are two questions here. Somebody has texted me. To be honest, I'll need to even sit down and have a clue at it, but have a look at it in depth when I'm less tired. But okay, the first question that was asked here was, so that as we go to close, was on regulation of financial services. Yeah. So I presume this is under the topic of commercial transactions, under the unit commercial transactions, topic financial service and systems, financial services and payment systems. So when you're told about regulation of the same, you can just mention a few acts. The CBK has a role, the central bank, the CBK Act. You can also mention the National Payment Systems Act. It also has a role. When it comes to financial services, data protection also comes into play. So Data Protection Act is there. And so many acts. It's so many acts. There's also the Capital Markets Authority Act. It's endless. You can just tie them down slowly by slowly when you're asked regulators in financial services. The CBK, we have the CMA, Capital Markets Authority. We have, what else? Yeah, is open and done. And then the second question was, a girl goes to KFC, tries to pay with ATM card but fails. Then she pays with cash. Then on her way out, she receives notification that transaction with card is successful. She goes back in to ask for a refund. Discuss. The second question, another scenario, the guy receives a call from a mobile lender telling them to tell the borrower to pay. He comes to you seeking advice as wakili, advice. Now, there are three questions I'm seeing. We addressed them already. The issue of person who buys land and then dies, and then the vendor dies beforehand, and so forth. Oh wait, there's another question here. At least this one there's the third one, the last one. Guy selling land dies. The deposit is already paid. The purchaser wants transaction completed. Mrs. Ruto follows up with another question. On what clause of the sale of land agreement may the purchaser rely on? It's a completion clause, the one that lays out completion. So if you fail to complete, the remedy is under the completion. Okay, now for the one who wants to contribute or attempt or assist on the issue of where you pay and then when you're walking out, something happens. Gitao, please go on. Gitao Samuel.
I can pick up from your last. It's called a completion, the late completion under condition 13 point. Condition 13
yes,
point.
Exactly. Yes.
The condition.
Where you send out a completion notice and you say that you are ready, able, and willing to comply, but this other party has not. And then after you've done that, and 21 days have lapsed, you do what? You have your remedies under the conditions of sale as you've rightly put out.
That and they are both the obligations for the vendor and the remedies also, if I must state so. For the person who has been called by a mobile lender, we had discussions with some fellow councils, and some of the things we said. First of all, you shall consider the aspects of contracts and the concept of privity of contracts. If it's not me who borrowed the money, why are you calling me? And it's not me who borrowed the money directly. It's my friend or a family member, and I'm not a guarantor. So through the aspect of privity, I am not supposed to be called. Also, we were looking at the concept of data protection, because by that it means that the mobile lender service has infringed your privacy, your data. Your data has taken your data, that's infringing your privacy. I can't remember. Is it Article 39, which provides for privacy rights? On the payment by KFC, what I think the lecturer was trying to see is if you know how a payment system works, from the recipient to the end receiver. So some of the things we saw, there's a judge case which he sued under defamation where he tried to pay, and
Justice Ombija. Justice Ombija.
It's the Justice Ombija case. He was trying to pay for services, and I can't remember the supermarket specifically, and it failed, and he sued under defamation. So from that scenario, you can sue the bank. But also, there was a concept because the payment is via the medium. You can't sue the card owners. So that was the initial area we were looking at. But we also said as a Kenyan, you just go to the counter and ask for your refund, because in case you can't, the bank, it takes time if you want to recover. So those are some things we talk.
Nicely put. Nicely put. Nicely put. On the first one, on the card, yeah, that's nothing more to add. On the issue to do with the card, you have your contract is between you. It's between you and the banking institution. Yeah? So you can go to the card. Nicholas Ombija, that's a very good authority. I think it was KCB, if I'm not wrong. It was awarded damages of upwards to 2 million. And then, yeah. So you go in and ask for the refund. The fiduciary duty lies with this thing. What's it called? Is it the bank? Yeah, the bank. So yeah, you, the client, and the bank. So you can go claim it at the bank. And then if you have credit cards or maybe debit cards, there's this concept of chargebacks. There's a concept of chargebacks whereby you can go claim later on. Let's say you've been charged for something and it was erroneous and so forth. You can go claim for it, and the bank will reimburse you and so forth. So yeah, that's very good analysis. And then the other one, guy receives call from mobile lender telling him telling them to tell borrower to pay. Now this is one thing. Actually, these are that's the thing to do with data protection. How did they get your data in the first place? That's one. Yeah? The other thing, it's between the borrower and who? And the banking or the lender. Why are they bringing you into this thing in the first place? And they can sue. And there's a case where it's actually right now in court. Allen has sued some lending company because of that. So yeah, thank you for that. So yeah, I think those are the questions that I was sent on WhatsApp just a few minutes ago. I'm seeing Noah has his hand up and Munyoki. You guys can conclude.
Lonka, if I can conclude, I also received a question.
Just if I may, before we proceed, I have an interjection. Before you proceed, I have an interjection on something that was said on the issue of the credit card and Justice Ombija and the whole issue of defamation. I'm a bit confused on how defamation would apply here, because I believe in that case there was literally like humiliation, like public humiliation, like something like it was actually, I think, even published, and it was it was just the whole thing. But for you, a KFC, saying you have not, I don't think from the facts given we can actually get a substantive course of action as regards defamation. So that's my concern.
So long as
Can I be allowed to respond to that, to bite the cherry on behalf of Samuel Duo, as I said?
I know you can go ahead because you're having that discussion with you.
Yes, so I'm holding the brief of brief of Council Duo. So you see, the concept is, what are the challenges with the national payment system? So it's not a substantive issue about defamation. It is the concept that they can fail sometimes. So they can fail you. So who do you sue? You get, so like if you know, delays, it can delay. Maybe you are using your card, you want to eat, you are so angry at KFC, then it delays. And even maybe now you did not have cash to pay. You say you will be thrown into disrepute and odium. So you use the concept of justice ombija just to show or to highlight the consequences or the shortbacks or the pitfalls that are accompanied with this issue of the national payment service systems. I don't know whether I have made it worse.
I know, Juma, you're spot on, because the reason why we chose the Ombija case is to show who's to sue in that case. Because in the Ombija case, he chose to sue KCB rather than Visa or MasterCard. So if he chose Visa, it wouldn't have applied, but he chose to sue KCB Bank. That's why from the Ombija case, you can imply that concept of who to sue in case of a card failure. That's what we were looking for.
Okay, I stand guided, but I still think defamation is far stretched for this scenario. I do get the whole aspect that you're using it as an avenue, like as a piggy bank to say that you can sue the bank for breach of contract. But again, defamation, I don't know. I'm still lost, but I stand guided. I guess it would apply.
No, this is a beauty of law. There's no definite answer. You guys will make great litigators, and one day that will be settled in court before a judge. Maybe I will be in the Supreme Court or somewhere and decide. But you both, the good thing is all of you are making solid arguments. And for purposes of orals, you all have 19 if you go argue your case. So you've all given solid answers. That's the thing.
Very fast.
Yes.
Very fast, just to make my learned friend
yes, Dido,
understand how defamation comes in. I also once in a supermarket and tried to pay through M-Pesa and it delayed. And then they said, hiyo ndio tabia yenu, mnafanyanga hivyo. Then I told them, then I had to pay through cash. Then later when the message came, I told them, sasa mliniharibia jina hata mbele ya kila mtu. So in such a circumstance, unaona, hapo naye I was supposed to sue for defamation, vile tu mimi ni Mkenya. So the second part also on issues to do with defamation, even dishonored checks, you can sue for defamation. When you do a check and then it is dishonored, it's like they are saying they are damaging your reputation. You can also sue for defamation. In simple.
I think Pam is getting an issue because you can't sue the bank for defamation. Why would you sue even I'm with her, why would you sue the bank for defamation? The people you're supposed to sue is the supermarket or the place that has caused you that harm. The bank, I would probably sue them negligence.
Esther, that's actually not my point. Actually,
that concept of suing the bank is long determined on defamation. It is long. There is even a common law decision on it. Maybe I can lay my hands on.
Oh yeah, I get the point. I was just thinking out loud. Why would you sue the bank for defamation in this point?
Because you have the money, you have a customer and a relationship with the bank.
Right.
Okay, let me give you the facts. Yeah? You have Nicholas Ombija. He is a highly renowned judge. Yes, he goes to a supermarket and he wants to pay. When he's swiping his card, the bank says he has no money. Now there are 10 people waiting for him in line and they are all looking at him, waiting for him to clear up so that they also pay. He tries again. It says you don't have money. And somebody there knows, hey, this person is a judge and I should kulipa this thing and this thing and this thing. It's some sort of character assassination and it damages your reputation. You become embarrassed and it damages your reputation. That is why, and it's because the supermarket doesn't have a fiduciary duty to you to ensure that your card works all the time. It's the bank, because the bank deducts charges from you to give you services, yeah, and all. So if you suffer any embarrassment because of the failure of banking systems, you can sue the bank because of what? The embarrassment. So for Mbija, amekaa kwa line, there were so many people behind him, and then his card is declining. So what did he do? He went and sued and he got upwards of 2 million shillings. So forth.
Oh yeah,
That's
it's
how
okay.
defamation comes in.
Yeah, I understand the rationale.
You see,
What
the
2.5
thing is, I'm looking at the case right now, and my issue is this guy is even published, some information regarding that mishap with the bank, and I think that's why it attracted a cause of action for defamation. My issue was you walk into a KFC, your card has issues, and you pay via M-Pesa or via cash, and then you go back, you find out like the payment has been done. I don't think your first cause of action should be defamation, in my opinion. I think that is because with this case, the circumstances were quite particular, and that is why in above and beyond the breach of contract, they went ahead and got libel and the other things, defamation. But when it comes to this KFC situation, I don't know. But again, like as long as you argue your case, I think it will suffice, I guess.
I think Munyoki, you never got the point that we were placing before. We weren't saying she will go for defamation. We were saying the proper person to sue. Because from this transaction, the bank is the one that gives the money or provides for the transaction to happen. The visa or the card is the medium that is used to pay. Then the supermarket is the end receiver. So the problem here is there's an issue between the medium and the bank. And who is suffering in this case is the person who is supposed to pay. So here, you won't sue for defamation. You won't sue for defamation. You are just saying from that obvious case, the proper person to sue or to seek for redress, you'll have to go back to your bank. The bank will sort you out, or you go back to the counter. That was what we were saying.
Okay, then I stand guided. Thank you. I stand guided. Thank you.
And the relief that you will decide to get against them, it is now upon you. So here is just the proper defendant is the bank.
Thank you.
Okay. Now, Noah, your hand is up. Go on.
Yes, I wanted to introduce a novel thing before my sister Esther was being scratched. But mine was a very unique question that was asked by Melissa Ngania, and I found it very lethal. But however, more realistic it is, but it's not for a student, or it's not covered in the coursework. So if I got the question correctly from the student who asked me, basically, if I could just give it in a scenario. For instance, Juma has earlier on hired Esther's services as an advocate. The matter is concluded. Mr. Juma lost the case, so let's assume it's an employment matter. So Esther has to pay the claimant certain amount. Now Esther, upon realizing Mr. Juma hakuhandle hiyo kesi vizuri or is very fake Ama's ID, remember the judgment is out. So Esther decided and say no. We cannot continue working with Mr. Juma. I need another fresh advocate. So she picks Ms. Pamela. So the question that Ms. Ngania posted to that question is, how will Ms. Pamela now will Ms. Pamela take over the matter? So the problem with this question is that, yes, it's a very good question, but I thought it's not covered in the coursework. So what I thought, looking into that question, I asked the student what did she answer. Then given that she was telling me, oh, I panicked, the question was hard, sijui nilijipata nimesema sijui notice of change of advocate, sijui what, and I told her
No, you're muted.
Solanka, may I try that to answer that question and then I can be guided?
I didn't even hear it. I think my network connectivity went down, but please, just go on. Go on.
From that scenario, I think what I've seen and maybe what I know, since the new party will be appealing, what the client will have to have completed the payments of accounts in the former advocate. If she has completed, she'll ask for the documents, the relevant documents from the former advocate, and the former advocate will send them to the new advocate. Actually, the new advocate will ask for them. It's done through a letter. I can't remember the full initials of that letter. So after taking this letter, then they'll file an appeal of that case, and then they'll enter as advocates for that matter, because now they'll be doing a new transaction. Because there's a specific, it's called a Mchina case, which gives a court of appeal shall hear a case as a first instance case. So anything that shall be brought to the court, it should be regarded as new and not something that has previously been had. That's how I'll have answered that.
That's I didn't even hear the question. But
Solonka.
Maybe.
Oh, the question was what happens in the instance where I have a matter, it has been handled by probably the High Court. I was not satisfied with the decision because I thought that my lawyer was not, or my advocate did not represent me adequately. And then I want now to change the advocates. So actually Noah is here again. So how do you proceed with that matter? So that was the question that Noah asked.
Yeah, Gita gave a very good answer then. Noah, please go on.
Solonka, sorry, I was dropped out. Am I clear now? Hello?
Yes, you are. No. Yes, you are.
Oh, was somebody attempting to answer it?
Yes, yeah, Gita gave a very good answer.
Yes, May I repeat the answer? No.
Yes.
From your question, what I understood is there's a new party after now they are lodging an appeal. So I don't think one will do a notice of change, because a notice of change comes during the subsistence of a matter that has not already been heard and dispensed of. So from my own opinion, what will have been done is the new advocate will send a request to the old advocate to present the copies or the whole file to the new advocate. If there is any sense of no payments of the former advocate shall place an application for taxing of bill of costs. Because this, if there are cleared accounts, now the new advocate will take in place and will file the matter afresh as an appeal, because now the matter will be heard as an appeal and will come into representation without even filing a notice of change. Because if you look at the Mchina case, which gives the jurisdiction, the locus for appeal cases, that all matters of appeal shall be heard as a new matter and should be dispensed as something that has never taken place. That's how I'll have answered.
Oh, that's new. The question that was posted just before I got dropped out, what happened, or what the Ms. Ngania asked was, what will the new advocate do? So I don't know if you have tackled that part of what the new advocate will do. Remember, the question is, the judgment has been given, so, and you wish another advocate to come on record. We don't know the purpose why he's coming on for record, maybe for purposes of execution or appealing. But the question is, what will the new advocate do? So this is what the new advocate will do. And I realized that this is a novel area. So what we will do is that we'll make an application. The new advocate will make an application to court, to that particular court that issued the judgment. So he will make an application to come on record. That is the application. It's another application called an application to come on record. The enabling provision being Order 9, Rule 9. So what you will do, the first order that you will seek is that leave be granted. It's through notice of motion. So leave be granted by the court for the firm of, Ms. Pamela to come on record on behalf of the applicant. Then you plead costs. So one of the grounds, the grounds that must clearly come out is that, one, for instance, assuming that this was an employment matter, so first you will say that the respondents filed an employment cause against the applicants. Then previously the firm of Juma was on record for the applicant, and the third ground will be the applicant has appointed the firm of Pamela to come on record. Then you also have to state the other ground is that the judgment had been entered on this date in favor of blah, 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 a sum of the sum that was issued. And, the other things that you need to show is that this application has been brought in good faith and without reasonable delay. So what we'll have to annex behind that application will be, one, the letter of instruction. So you clearly, there's a change of advocacy, the advocates who are supposed to come on record. So one, will have to show the instruction note or the letter of instruction. Number two, given that this is a matter that has the judgment has been entered, you must also annex in the supporting affidavit, you must also annex a copy of the judgment. So those two things must appear in that application as annexures. So that's it. I wanted you people to get the gist of that. It's a new thing. Yes, Esther.
If I may ask, you've said the new advocate will plead costs. Ama nimesikia zangu.
Yes, the cost of the application, not the entire suit. The cost of that particular application. Yes, Juma, maybe you can aid.
Yes, Noah, thank you very much for that concept. I think even me, it has eluded my mind, but I've seen it happens, especially even when the matter is proceeding to execution. Realize that now the judgment data has brought in a different they have changed their advocates. Judgment data, they become very hostile to their former advocates like me, Juma, now. They say I'm very poor and so on. So they bring another one. And the other one, there's those issues. I think they always say that you cannot just change them by using, I think there's a ruling, a notice of motion. No, sorry, a notice of appointment. You need to bring in a substantive application the way you've said. So I think it's a very good thing. It is normally, when it comes to execution proceedings, it's normally there. Thank you.
I have a follow-up question. Is it possible, because I think I would have approached it differently, like how Samuel went the appeal way, because now the Court of Appeal will just listen to the matter newly, and then now as the new advocate, I'd probably just take over from the appeal part, seek orders for stay of execution until the hearing and the determination of the suit, of the appeal, that is, and then finish it there. So I'm still not getting why we are making an application if my client wants to appeal the decision. I am not getting that part.
Yes, Samuel.
Also, no, I think there's something because even if you're lodging this application, you have to notify the former advocate. You just can't go directly to court, because even if you also consider like a notice to change, notice of change of advocate, you have to notify the former advocate first, so that if they can raise an objection to the new application, they can raise to the new application, they can come to court. You just can't move to court directly, and then because there's a change, you have to notify the old advocate. I think
Nani, Mr. Puo, what happens? Order nine. Yes.
Sorry, could I maybe tell Dua and Esther the rationale why it is an application? The rationale behind it is simple. The advocate who is coming on record, the former proceedings and instructions, they had been exhausted. The case was exhausted. Actually, the case ends after judgment, I think, has been issued normally. And even you see the decrees are served on the judgment data in person. Normally, they are not even served on the advocates. So, but when they are bringing a new advocate, as me, when I'm coming as a new one, you make an application and you serve the former advocate the way you're saying somewhere, so that they can be able to be notified that this guy is changing the advocate, so that if they have a claim against me, against the client, on the issues of fees, the way you say, they can object or they can raise their motion also. Through the advocate client bill. Of course, they can file it in court as maybe a miscellaneous application. So that's why it's not like the other way where you just do a notice of appointment or a notice of change, because maybe there is some costs or fees that the client has not squared with you. So you'll be served with the application, and then you can raise even your objections to it. Because the clients, you realize at the end of the process, execution is something that's very intricate. I don't know whether it is even palatable for us to talk about it now, but you realize, you have very many advocates, and all of you want your fees from this one client. There are some clients who are difficult, and they're like that. So I think that is why it is by way of an application, not by the conventional way.
Yes, I wasn't disputing the application. I was just enforcing the mode of you have to serve. I think Noah had missed that point, the service to the former advocate.
Yes. I agree with you. What Order 9 basically says, there are two ways in which you can effect change by an order of the court. So one, you can do an application. I'll send you a copy. I did one. You do an application, and it's true, you have to serve all the parties in that application. So it will be the client, the adverse party, and the old advocates who will be served with that application. Another way, you can do a consent, which you can file between the outgoing advocate and the proposed incoming advocate. That's basically what Order 9 says. So if you wish to effect change of advocates after judgment is done, so there are two ways. You can do a consent between you and the old advocate, or you can do an application with notice to all the advocates. That's what Order 9 says. So I thought it was, because next week I might forget, I thought it was if you could have the gist of the questions. So that's it from me.
Thank you.
Mr. Solonka, are you asleep?
I am here. Sorry. Yes?
Yes, I'm done.
Oh, okay, that's fine. That's Paul, I got distracted a bit. It's late, 11:30. Yeah, so I think we can close up for today and then catch up next week. Unless there is anyone. No, we're not opening it up. So all the best in your orals this week. For those who are doing them this week, remember the key is confidence and how you answer the questions, not the questions that come your way. So you may get easy questions but end up scoring low marks, but you may get hard questions and still end up scoring high marks. So all the best. I wish you nothing but the best and you will hack it. Have a great and have a good night.
Thank you. Good night.
Thank you.
Okay.
Thank
Good
you.
night.
Good night.